Good morning to everyone. Please take your seats. ఆనరబుల్ మెంబర్స్ అందరూ కూడా తమ తమ సీట్లలో కూర్చోవలసిందిగా కోరుచున్నాం. న్యాయవాద మిత్రులందరూ కూడా కూర్చోవలసిందిగా కోరి ప్రార్థిస్తున్నాం. ఈ కార్యక్రమం మొదలు కాబోతుంది కావున గౌరవ సభ్యులందరూ కూడా కూర్చోవలసిందిగా కోరి ప్రార్థిస్తున్నాం. గౌరవ సభ్యులందరూ కూడా కూర్చోవలసిందిగా కోరుతున్నాం. Good morning to everyone. I welcome the honorable judges, chairman and members of the Bar Council of Andhra Pradesh, judicial officers, office bearers of the Narsapuram and Palkal Bar Associations, senior advocates, advocate brothers and sisters to the seminar. Now, I request Sri Ganta Ramarao Garu, chairman Bar Council of Andhra Pradesh and president of today's seminar to come out to the dais and adorn the chair. I request Srimati TRS Lakshmi Garu, lady representative of Bar Association Narsapuram, to present a bouquet to the honorable chairman. Now I also request the chief guest of today's seminar, Honorable Sri Justice Akalu Venkata Seshasai Garu, Judge, High Court of Andhra Pradesh, to come out to the dais and adorn the chair. I request Sri N. Kumar Ratnam, Vice President, Narsapuram Bar Association, to present a bouquet to the Honorable Justice Sri Akalu Venkata Sai Garu. Now I request the Honorable Sri Justice Chekati Manavendra Rai Garu, Judge, High Court of Andhra Pradesh and Administrative Judge, West Godavari District, to come out the dais and adorn the chair. Now I request Sri R.V. Surinarayana Garu, Advocate, to present a bouquet to the Honorable Sri Justice. Now I request the Honorable Sri Justice Nainal Jayasuriya Garu, Judge, High Court of Andhra Pradesh, to come out the dais and adorn the chair. Now I request Sri Narin Srinivas Rao Garu, Library Secretary, Narsapuram Bar Association, to present a bouquet to the Honorable Sri Justice. Now I request the Honorable Sri Justice Satti Subbareddy Garu, Judge, High Court of Andhra Pradesh, to come out the dais and adorn the chair. I request Srimati Sobana Lakshmi Garu, Advocate, to present a bouquet to the Honorable Sri Justice. Now I request the Honorable Principal District and Session Judge Jeluru, Sri Purushottam Kumar Chintalapati Garu, to come out to the dais and adorn the chair. I request Sri Godi Satyanarayana Garu, Joint Secretary, Narsapuram Bar Association, to present a bouquet to this Sri Purushottam Kumar Garu. I request the Now I request this Sri A. Ramireddy Garu, Member, Bar Council of India, to come out the dais and adorn the chair. I request Srimati B. Pragati Garu, Sports and Cultural Secretary, Narsapuram Bar Association, to present a bouquet to the Sri A. Ramireddy Garu. I request Sri K. Chidambaram Garu, Senior Advocate Member, Bar Council of Andhra Pradesh, to come out the dais and adorn the chair. I request the Sri B. Sundara Ramamurthy, Advocate, to present a bouquet to Sri K. Chidambaram Garu. Now I request Sri B.V. Krishna Reddy Garu, Member, Bar Council of Andhra Pradesh, to come out the dais and adorn the chair. I request Srimati K. Durga Bhavani, Senior Executive Member, Narsapuram Bar Association, to present a bouquet to Sri B.V. Krishna Reddy Garu. Now I request Sri K. Bala Satyanarayana Garu, President, Bar Association, Narsapuram, come out to the dais and adorn the chair. I request Sri Kondeti Srinivas Garu, Advocate, to present a bouquet to Sri K. Balasachinarayana Garu. Now I request Sri G.V. Subbarao Garu, President Bar Association Palkollu, to come out the dais and adorn the chair. I request K. Annapurna Garu, Executive Member, to present a bouquet to Sri G.V. Subbarao Garu. Now I request the Chairman, Bar Council, Sri Ganta Ramarao Garu, to preside over the function. Thank you, sir.
Now the prayer by the advocate friends.
శరణు శరణు వినాయక శరణు విద్యా ప్రదాయక శరణు శరణు వినాయక శరణు విద్యా ప్రదాయక శరణు శరణు వినాయక శరణు పార్వతి తనయమూరుతి శరణు మూషిక వాహన శరణు పార్వతి తనయమూరుతి శరణు మూషిక వాహన శరణు శరణు వినాయక శరణు విద్యా ప్రదాయక శరణు శరణు వినాయక ನಿಟಲ ನೇತ್ರದ ದೇವಸುತನೇ ನಾಗಭೂಷಣ ಪ್ರಿಯಾನೇ ನಿಟಲ ನೇತ್ರದ ದೇವಸುತನೇ ನಾಗಭೂಷಣ ಪ್ರಿಯಾನೇ ಕಟಕ ಸಾಂಗದ ಕೋಮಲಾಂಗನ ಕರ್ಣಕುಂಡಲ ಧಾರಣೆ ಕಟಕ ಸಾಂಗದ ಕೋಮಲಾಂಗನ ಕರ್ಣಕುಂಡಲ ಧಾರಣೆ ಶರಣು ಶರಣು ವಿನಾಯಕ ಶರಣು ವಿದ್ಯಾ ಪ್ರದಾಯಕ ಶರಣು ಶರಣು ವಿನಾಯಕ.
Next program is lighting of lamp by the dignitaries on the dais. Now the welcome address by the President of the Narsapuram Bar Association, Mr. Satyanarayana.
ఈరోజు ఈ సమావేశానికి అధ్యక్షత వహించిన బార్ కౌన్సిల్ ఆఫ్ ఆంధ్రప్రదేశ్ చైర్మన్ గంటా రామారావు గారికి, అలాగే ఈ సమావేశానికి ముఖ్య అతిథిగా విచ్చేసిన పెద్దలు, గౌరవనీయులు, ఆనరబుల్ హైకోర్టు జడ్జి అయిన ఆకుల వెంకట శేషాయి గారికి, అలాగే ఆనరబుల్ అడ్మినిస్ట్రేటివ్ జడ్జ్ హైకోర్ట్ ఆఫ్ ఆంధ్రప్రదేశ్ శ్రీ మానవేంద్రనాథ్ రాయ్ గారికి, అలాగే మరో అతిథి గౌరవనీయులు ఆనరబుల్ హైకోర్టు జడ్జ్ నయనాల జయసూర్య గారికి, అలాగే మరో అతిథి గౌరవనీయులు ఆనరబుల్ హైకోర్టు జడ్జ్ ఆఫ్ ఆంధ్రప్రదేశ్ సత్య సుబ్బారెడ్డి గారికి, ప్రిన్సిపల్ డిస్ట్రిక్ట్ జడ్జ్ వెస్ట్ గోదావరి పురుషోత్తం కుమార్ గారికి, బార్ కౌన్సిల్ మెంబర్ కె చిదంబరం గారికి, బివి కృష్ణారెడ్డి గారికి, అలాగే బార్ కౌన్సిల్ ఆఫ్ ఇండియా రామిరెడ్డి గారికి, ఈ సమావేశానికి విచ్చేసిన, అలాగే పాలకొల్లు బార్ ప్రెసిడెంట్ సుబ్బారావు గారికి, ఈ సమావేశానికి విచ్చేసిన న్యాయవాదులకి, సీనియర్ అడ్వకేట్స్కి, మహిళా న్యాయవాదులకి, స్టాఫ్కి, అందరికీ కూడా, జ్యుడిషియల్ ఆఫీసర్స్కి అందరికీ కూడా హృదయపూర్వక నమస్కారాలు. ఈరోజు నర్సాపురంలో సుమారు 13 సంవత్సరాల తర్వాత ఇంత ప్రతిష్టాత్మకంగా మళ్ళీ ఈ సెమినార్ బార్ కౌన్సిల్ ఆఫ్ ఆంధ్రప్రదేశ్ ఆధ్వర్యంలో చేసుకోవడం, మా టెన్యూర్లో ఇది జరగడం మా అదృష్టంగా భావిస్తున్నాం. ముఖ్యంగా ఈ సెమినార్ కండక్ట్ చేయడానికి ముఖ్య పాత్ర వహించిన బార్ కౌన్సిల్ ఆఫ్ ఆంధ్రప్రదేశ్ చైర్మన్ గారికి, వారి సభ్యులకి, ముఖ్యంగా మా అడ్వకేటు, మా నర్సాపురం నివాసి అయిన కలిగినీటి చందమ్మ గారికి ముందుగా మా బార్ అసోసియేషన్ తరఫున, పాలకొల్లు బార్ అసోసియేషన్ తరఫున కృతజ్ఞతలు తెలియజేసుకుంటున్నాం. ఈ సెమినార్స్ అనేవి చాలా ఉపయోగపడుతూ ఉంటాయి. లీగల్ ప్రొఫెషన్ అనేది ఎప్పటికప్పుడు మనం యాక్ట్స్ అమెండ్ చేసుకుంటూ, ఎప్పటికప్పుడు అప్డేట్ అవుతూ, ఈరోజు మనం ఇంత నిష్ణాతులైన హైకోర్టు జడ్జెస్ ద్వారా మనం ఈ సెమినార్ కండక్ట్ చేసుకుని మన నాలెడ్జ్ పెంచుకోవడానికి అవకాశం కల్పిస్తున్నందుకు ప్రతి ఒక్కళ్ళు దీన్ని సద్వినియోగం చేసుకోవాలని, చివరిదాకా ఉండి వాళ్ళు చెప్పే అన్ని విషయాలు కూడా గ్రహించి తప్పనిసరిగా అందరూ ఉండాలని కోరుకుంటూ, ముఖ్యంగా 2 నిమిషాలు టైం లేదు కాబట్టి 2 నిమిషాలు ఇవాళ శేషాయి గారు కానీ, మా అడ్మినిస్ట్రేటివ్ జడ్జి గారిని, అదర్ హైకోర్టు జడ్జెస్ ఉన్నారు కాబట్టి, మాకు నర్సాపురం ఈ నర్సపూర్ బార్ అసోసియేషన్ అనేది చాలా పేరుగల బార్ అసోసియేషన్, పురాతనమైనది. మాకు ఇక్కడ నర్సాపురంలో మొన్న బైఫర్కేషన్లో మాకు డిస్ట్రిక్ట్ హెడ్ క్వార్టర్స్ అవుతుందని మేము అందరం కూడా ఆశించాం. అనుకోని కారణాల వల్ల, టెక్నికల్ ప్రాబ్లమ్స్ వల్ల అది భీమవరం వెళ్ళింది. మేము కోరుకునేది ఏంటంటే అడ్మినిస్ట్రేటివ్ జడ్జి గారికి, ముఖ్యంగా శాస్త్రయ్య గారికి, మా నర్సాపూర్ బార్ అసోసియేషన్ మీకు తెలుసు కాబట్టి ఇక్కడ కోర్టుది, మాకు ఈ బైఫర్కేషన్ ద్వారా ఏమన్నా స్పెషల్ కోర్ట్స్ వచ్చినప్పుడు ముఖ్యం మా గురించి మీరు తప్పనిసరిగా కన్సిడర్ చేయాలని, ఆ విషయంలో మీరు మాకు కోఆపరేట్ చేయాలని మనస్ఫూర్తిగా కోరుకుంటూ ఈ అవకాశం ఇచ్చిన బార్ కౌన్సిల్ చైర్మన్ గారికి కృతజ్ఞతలు తెలియజేసుకుంటూ సెలవు తీసుకుంటున్నాను.
సభాధ్యక్షునిగా క్లుప్తంగా నేను మాట్లాడతాను, ఎందుకంటే మనకున్న టైము సద్వినియోగం చేసుకోవాలి. నరసాపురం బార్ అసోసియేషన్ విషయం అందరికి కూడా తెలుసు. ఎంతో ప్రతిష్ట కలిగినటువంటి బార్ అసోసియేషను, ఎంతోమంది స్టాల్ వార్డ్స్ని ప్రొడ్యూస్ చేసినటువంటి అసోసియేషను, ఎంతోమందిని హైకోర్టు జడ్జిలుగా ఎలివేట్ చేసే అవకాశం కలిగినటువంటిది బార్ అసోసియేషను. డిసిప్లిన్కి మారుపేరైన నర్సాపూర్ బార్ అసోసియేషను. అందువలన ఇక్కడ నర్సాపూర్ బార్ అసోసియేషన్ రావాలంటే మా అందరికి కూడా సంతోషంగా ఉంటుంది. ప్రీవియస్గా కూడా 2 సార్లు బార్ కౌన్సిల్ ఈ అసోసియేషన్ వారి సహకారంతో ఇక్కడ సెమినార్ కండక్ట్ చేయడం జరిగింది. మరి అంతేకాకుండా ఒక ఎడ్యుకేషన్ ట్రైనింగ్ ప్రోగ్రామ్ కూడా వేరే ఇన్స్టిట్యూట్ ద్వారా ఇక్కడ ఏర్పాటు చేయటం జరిగింది. ఈ షార్ట్ పీరియడ్లో, అంటే ఎక్కువ టైం గ్యాప్ రాకుండా తక్కువ వ్యవధిలో మంచిగా ఏర్పాటు చేసినటువంటి బార్ అసోసియేషన్కి ప్రథమంగా కృతజ్ఞతలు తెలియజేస్తున్నాం బార్ కౌన్సిల్ తరఫున. అంతేకాకుండా ముఖ్యంగా మనం ఇక్కడ గ్యాదర్ అయినటువంటి మీరందరూ కూడా ముందు మిమ్మల్ని కంగ్రాచులేట్ చేయాలి. ఎందుకంటే మనకంతా తెలుసు అని అనుకునేటువంటి మనస్తత్వం నుంచి మనం తెలుసుకోవాల్సింది ఇంకా ఉంది అనేది రియలైజ్ కావటం ముఖ్యం. అంటే ఒకరోజు సెమినార్లో మొత్తం తెలియకపోయినప్పటికీ కూడా మరి ఎంతో విశేషమైనటువంటి అనుభవం కలిగినటువంటి మన జడ్జెస్ వారు అడ్వకేట్గా ప్రాక్టీస్ చేసినప్పుడు అనుభవించిన అదే కాకుండా, ఆ సంపాదించిన జ్ఞానమే కాకుండా యాజ్ ఏ జడ్జెస్గా మల్టీ ఫేసెటెడ్ ఎంతో విధమైనటువంటి ఎక్స్పోజర్ వారికి ఉంటుంది. అటువంటి వారు ఆ జీవితకాలంలో సంపాదించినటువంటి పరిజ్ఞాన్ని ఒక గుళికల మాదిరిగా మనకి ఇచ్చి మనం ఆ సంపన్నం అంటే ఆ జ్ఞానాన్ని సంపాదించుకునే అవకాశం కలుగుతుంది. కాబట్టి మరి ఇలాంటి అవకాశాన్ని మిస్ కాకుండా ఇక్కడికి వచ్చినందుకు మీ అందరికి కూడా కంగ్రాచులేట్ చేస్తూ, ముఖ్యంగా అన్నిటికంటే మనం ఫస్ట్ చూస్తే బీ ద చేంజ్ యూ విష్ టు సీ ఇన్ ద వరల్డ్. మనం ప్రపంచం అంతా ఏ విధంగా ఉండాలనుకుంటామో ప్రతి ఒక్కరం కూడా అలా ఉండగలిగితే ఏమీ ఇంకా అప్పుడు ప్రాబ్లం అనేది కనపడదు మనకి. ఈ ద్వంద్వమైనటువంటి అభిప్రాయాలు లేకుండా నా వాటికి వచ్చేసరికి ఒక రకమైన అభిప్రాయము, ఎదుటి వాళ్ళకి వచ్చేసరికి ఒక రకమైన అభిప్రాయం కలిగి ఉండటం వల్లనే మనకు ఉండే సమస్యలన్నీ కూడా ఉంటాయి. అందువలన అటు బార్ కౌన్సిల్ కానివ్వండి, బార్ అసోసియేషన్ కానివ్వండి, ఇండివిజువల్గా అడ్వకేట్ కానివ్వండి, గ్రూప్గా కానివ్వండి, మనందరం కూడా అందరం కలిసి ఒక్కొక్కళ్ళు అందరం కోసం ఒకళ్ళ కోసం అందరటువంటి ఆ స్నేహభావాన్ని పెంపొందించుకొని పరస్పర సహకారంతో ఇంకా కూడా ముందుకు వెళ్ళవలసిన అవసరం ఉంది. ఈ డైరెక్షన్లో ముఖ్యంగా లా అకాడమీ, ముఖ్యంగా ఎక్కడికి పోయినా కూడా నేను అది జరుగుతుంది. మొన్నే జ్యుడిషియల్ అకాడమీ మనకి ఫార్చునేట్గా మనకి ఇనాగ్రేట్ చేశారు సిజిఐ గారు. అతి త్వరలో మనం కూడా ఒక లాయర్స్ అకాడమీని ఏర్పాటు చేసుకోవాల్సిన ఆవశ్యకత ఎంతైనా ఉంది. అందువలన నాట్ స్టాండింగ్ కొత్తగా వచ్చిన జూనియర్ కానించి బాగా ఈవెన్ 40 సంవత్సరాలు 50 సంవత్సరాలు ప్రాక్టీస్ చేసిన వారికి కూడా కొత్తగా వచ్చే మార్పులు, కొత్తగా వచ్చే లా, మరి జడ్జిమెంట్స్ ఆఫ్ ద సుప్రీంకోర్టు కానివ్వండి, వరవడి కానివ్వండి, కొత్త పద్ధతులు కానివ్వండి, టెక్నాలజీ కానివ్వండి, వీటినన్నింటిని కూడా ఎప్పటికప్పుడు అడాప్ట్ చేసుకొని మనం రెలవెంట్గా లేకపోయినట్టయితే ఈ సమాజంలో మన రోలు తగ్గిపోతుంది. మనందరికీ తెలిసిన విషయమే. అవసరమైనప్పుడు మరి ఆ స్వతంత్ర సముపార్జన సమయంలో మన యొక్క పాత్ర ఏమిటి, ఈరోజు మన పాత్ర ఏమిటి అంటే చాలా గ్యాప్ వచ్చింది. మనం ప్లే చేయవలసిన రోల్ని ఎక్కడో కొంత వెనకబడిపోతున్నాం అనిపిస్తుంది. అందువలన నాలెడ్జ్ ఎక్వైర్ చేయటమే కాకుండా సామాజిక స్పృహ, సామాజిక బాధ్యత వాటి వల్ల కూడా ఎప్పటికప్పుడు మనం మన్నం చేసుకొని మళ్ళీ ముందుకు వెళ్ళకపోతే మనం ఇర్రెలవెంట్ అయిపోతామో అని అనిపిస్తుంది. ఎందుకంటే మనకి స్వతంత్రం వచ్చే క్రమంలో మనం ప్లే చేసిన రోలే కాకుండా ప్రథమ పార్లమెంటులో 33% ఉన్నటువంటి న్యాయవాదులు, 33 అంటే 1/3 ఆఫ్ ద పార్లమెంట్ మెంబర్స్ బిలాంగ్ టు దిస్ ప్రొఫెషన్. ఈలోన మరి ఓన్లీ 5%కి పడిపోయింది. 4 to 5% ఈ రోజున పార్లమెంట్లో రిప్రజెంట్ చేస్తున్నాం. అంటే సమాజం మన పైన ఉన్నటువంటి కాన్ఫిడెన్స్ని, సమాజం పట్ల మనకున్న బాధ్యతని ఎంతో కొంత తగ్గిస్తుంది అని అనటంలో సందేహం లేదు. అందువల్ల ఒక్కసారి రీఓరియంటేషన్ అయ్యి మళ్ళీ మనం ఒక్కసారి పునర్నిర్మాణం చేసుకొని ఈ సమాజంలో మన యొక్క పాత్రను మళ్ళీ పోషించాల్సినటువంటి అవసరం, ఆవశ్యకత ఎంతైనా ఉందని తెలియజేస్తూ ఈ అవకాశాన్ని మనం సద్వినియోగం చేసుకుందని నా తోటి మిత్రులు కూడా తర్వాత మాట్లాడేవారు క్లుప్తంగా డైరెక్ట్గా మాట్లాడి మనం ఈ యొక్క సెమినార్ యొక్కని మ్యాక్సిమం పొందడానికి మనం వినియోగించుకుందామని కోరుకుంటూ, నౌ ఐ రిక్వెస్ట్ ది ప్రెసిడెంట్ ఆఫ్ ది బార్ అసోసియేషన్ పాలకొల్, my dear friend G.V. Subbarao, to give his message briefly.
గుడ్ మార్నింగ్ ఎవ్రీబడి. ముఖ్యంగా ఈరోజు ఈ కార్యక్రమానికి అధ్యక్షత వహించిన బార్ కౌన్సిల్ చైర్మన్ గంటా రామారావు గారికి, అలాగే వేదిక పైన ఉన్న హానరబుల్ హైకోర్టు జడ్జెస్ ఆకుల వెంకట సాయి గారికి, మానవేంద్ర రాయ్ గారికి, నయనాల జయసూర్య గారికి, సుబ్బారెడ్డి గారికి, అట్లాగే బార్ కౌన్సిల్ డిస్ట్రిక్ట్ జడ్జి కుమార్ గారికి, అట్లాగే మిగిలిన బార్ కౌన్సిల్ మెంబర్స్కి, ఇక్కడికి విచ్చేసినటువంటి అందరికీ కూడా నా నమస్కారాలు తెలియజేస్తాను. ముఖ్యంగా నేను చెప్పేది ఏంటంటే, మనకి కేసెస్ అవి కూడా చాలా ఫాస్ట్గా చేయండి అని జడ్జెస్ మీద ప్రెజర్ ఇవ్వడం, అలాగే అడ్వకేట్స్ మీద ప్రెజర్ ఇవ్వడం జరుగుతుంది. అయితే ఈ విషయంలో కొన్ని విషయాలు మీ ముందుకు నేను తీసుకురావాలనుకుంటున్నాను. మనం గతంలో కేసెస్ చేసేవాళ్ళం. కేసెస్ చేసేటప్పుడు మనకి ప్లెయింట్ రాయడానికి ఒక 3 పేజీల ప్లెయింట్ రాసేవాళ్ళం. అదే ప్లెయింట్ ఇప్పుడు రాయాలంటే దానికి వెరిఫికేషన్ ఎఫిడవిట్, ప్రూఫ్ ఎఫిడవిట్, అడ్రసెస్ మెమో, ప్రొఫామో, ఇట్లా రకరకాల ఫామ్స్ అన్ని పెట్టి మనకి పెట్టారు. అయితే మనం లాంగ్ కాజ్ టైటిల్లో మనం అడ్రసెస్ మెన్షన్ చేస్తాం. అడ్రసెస్ ప్లెయింట్లో ఉన్నప్పుడు మళ్ళీ మెమో అనేది, అడ్రసెస్ మెమో అనేది ఉండడం అనేది అది సబబు కాదనేది నా విశ్వాసం. అలాగే ప్రొఫామా అని పెట్టారు ఈ మధ్యన రీసెంట్గాని. ఆ ప్రొఫామా పెట్టడం వల్ల ఏంటంటే యాక్చువల్గా మనకి కాజ్ టైటిల్ అది ఉన్నప్పుడు ఆ ప్రొఫామా వేరేది పెట్టడం కూడా అది ఇబ్బందికరమైన పరిస్థితి. ఎందుకంటే మనం కేసెస్ స్పీడ్గా చేయాలనుకున్నప్పుడు కొన్ని ప్రొసీజర్ తగ్గించినట్లయితే బాగుంటుంది. ఎందుకంటే ఇంత లెంగ్తీ ప్లెయింట్ మనం తయారు చేసి వేస్తాం. అదే జడ్జెస్ కూడా అది చదవాలి, అన్ని దాంట్లో తప్పులు ఉన్నాయి లేదని, అది మనకి ఇబ్బంది, అట్లాగే జడ్జెస్ కూడా ఇబ్బంది. కాబట్టి ఈ విషయంలో దీన్ని షార్ట్ రన్ చేయాలని నేను కోరుతున్నాను. అలాగే కేసెస్ స్పీడ్గా చేయడం కోసం మనకి లోక్ అదాలత్ ఏర్పాటు చేయడం జరిగింది. లోక్ అదాలత్ ఏర్పాటు చేస్తే దాంట్లో ఏంటంటే లోక్ అదాలత్లో సెటిల్ అయిన వాటికి మీకు ఫీజు వెనక్కి ఇచ్చేస్తామని చెప్పడం జరిగింది. ఇంతవరకు ఎన్ని కేసెస్లో ఫీజు వెనక్కి తీసుకున్నారండి మీరు అందరూ అడ్వకేట్స్? ఎవరూ తీసుకోవట్లేదు. ఎందుకంటే అది కలెక్టర్ గారి దగ్గరికి వెళ్ళాలి, అక్కడికి అప్లికేషన్ పెట్టాలి, అక్కడి నుంచి రావాలి. సో ఈ ప్రొసీజర్ తగ్గించి మనకి లోక్ అదాలత్లో సెటిల్ అయినప్పుడు అది వెంటనే మనకి ఈ చెక్ వెంటనే పార్టీలకి కోర్టులోనే ఇచ్చి నట్లయితే మనకి ఇంకా స్పీడ్గా కేసెస్ అవి అవడం జరుగుతుంది. కాబట్టి ఈ విషయంలో కూడా గమనించి దానికి చర్యలు తీసుకోవాల్సిందిగా కోరుతున్నాను. అట్లాగే జడ్జెస్ మీద ఈ టైంలో ఇన్ని కేసులు చేయండి ప్రెజర్ ఇస్తున్నారు. అది జడ్జెస్కే కాదు, అడ్వకేట్స్ కూడా చాలా ఇబ్బంది. ఎందుకంటే కొందరు సిక్ పర్సన్స్ ఉంటారు. ఆ సిక్ పర్సన్స్ ఇన్ టైంలో కోర్టుకి రాలేని పరిస్థితి ఉంటుంది. అట్లాంటి రాలేని పరిస్థితిలో వితిన్ టైంలో మనం చేయమంటే మనకేమో జడ్జెస్ టైం ఇవ్వరు, మనం కేసెస్ చేయాలి, ఎట్లా వీలవుతుంది? కాబట్టి కొన్నిసార్లు ఈ ప్రొసీజర్ల వల్ల చాలా ఇబ్బందులు కలుగుతున్నాయి. దాన్ని కొంచెం సరళం చేసి ఇబ్బంది లేకుండా చేయమని కోరుకుంటూ నేను సెలవు తీసుకుంటున్నాను.
Thank you, sir. Now, Chidambaram, Honorable Member, Bar Council of AP, who is instrumental for today's program, will give his addresses.
Good morning, everyone. today's President and Chairman, Bar Council of Andhra Pradesh, Sri Ganta Ramarao Garu, the Chief Guest of the seminar, Justice A.V. Seshai Garu, Guest of Honor, Honorable Sri Justice Chikati Manavendra Rai Garu, Administrative Judge, West Godavari District, His Lordship Justice Nainal Jayashwarya Garu, and His Lordship Justice Satya Subbareddy Garu, the Honorable District Judge Purushottam Kumar Garu, Member Bar Council of India, my friend A. Ramireddy, Member Bar Council of Andhra Pradesh, Krishna Reddy Garu, my beloved friends Mr. K.B. Sachanarayana and G.V. Subbarao, Presidents of Narsapur and Palkal Bar Associations, Judicial Officers, Bar Council members, Senior Advocates from various places of West Godavari District, and members of the Narsapur and Palkal Bar Associations. I welcome you all to this seminar. I thank the Honorable Judges for accepting the invitation of Bar Council of Andhra Pradesh and the invitation of the Bar Associations of Narsapur and Palkal to participate in this seminar. I welcome you, sir. I thank the Honorable Judges for readily accepting our invitation and to share their knowledge and experience in this seminar. We are eagerly waiting for your presentation in the subjects already notified in the invitation card. And the Bar Council is and has been conducting seminars for the benefit of the members of the bar. About 3 months ago, we have conducted seminar at Vishakhapatnam. About 1 month ago, we have conducted seminar at Elur in our erstwhile West Godavari district. And now, within the span of 3 months, we are conducting this seminar in Narsapur. We have been conducting this seminar for the benefit of the members of the bar, particularly the young members of the bar, to equip with the recent laws and also to equip with the day-to-day functioning of the courts and bar associations. Now the Bar Council is not only extending the welfare measures and also extending the benefit of conducting seminars for the benefit of the members of the bar. Now at present the Bar Council is providing welfare fund to a tune of 4 lakhs to the families of the advocates who passed away, and the government is granting 4 lakhs towards matching grant. Besides that, we have been providing financial assistance at 50,000, and also we are providing death benefits and financial assistance from the fund of the Bar Council of India. Now the government has promised to allocate 100 crores to the advocates community. As promised by the Honorable Chief Minister, he has sanctioned 100 crores to the advocates community, out of which 24 crores have already been disbursed to the Bar Council, out of which the Bar Council has disbursed almost 12 crores rupees by of loans to the members who are facing stringent financial circumstances due to COVID-19 pandemic. The Bar Council is also providing health insurance to its members. For the last 2 years, we have provided health insurance by collecting only 1,000 rupees from the member, and remaining premium amount is being paid by the Bar Council from the funds allocated by the government of Andhra Pradesh. Now 2 years have already completed. Now we are entering into the 3rd year. I request the Chairman, Bar Council of Andhra Pradesh, to pursue with the government once again to continue the insurance scheme this 3rd year also, in the interest of the members of the bar. Thank you for giving me an opportunity, and I thank all the members and committee, executive committee and members of the Palakol Narsapur Bar Association in making arrangements for conducting seminar in a smooth manner. Now we are waiting, we have galaxy of judges on the dais. We are waiting for their speech and for their sharing of their knowledge in respect of the subjects notified. Thank you, one and all.
Thank you, Chidambaram Garu. Thanks for reminding me about the insurance, because it is the occasion we have to remind all of you, because insurance scheme is one of the best schemes available, and it is so tailor-made, and it is the best available schemes. But unfortunately, we expected at least it will cross the 10,000 last occasion, but it reached only 9,000 people availed that benefit. But unless all of you come forward, and only, that means even half of the people did not come forward. So though it is a beneficial, because what you are paying is only less than only 1/3 of the premium, and rest of the amount is being paid by the Bar Council as well as from the government fund. Again, we are trying to this time also to get assistance from the government in the same form. 1/3 will be funded by the government, 1/3 from the Bar Council, 1/3 from your contribution. But unless you come forward, because all of you come forward, entire nearly 38,000 people come forward, it will be less than even half of the amount which we are paying premium. We can get that policy with that amount. Therefore, please kindly keep in your mind, by taking the policy, partly not only personally, but also all the family members will be covered to certain extent. At least it will cover to risk to some extent. Please kindly keep in your mind and take advantage of availability of the policy. Now I request the chief guest of the today function, Sri Seshashai Garu, to address all of us. It is a moving spirit, and every time, everywhere, wherever we conduct, he is readily available and taking pains and coming for all of us. I request the chief guest of this function, Sri Akula Seshashai Garu, to address us, to inaugurate the seminar.
నేనండి హైకోర్టులో ప్రాక్టీస్ చేసినా కూడా నాకు మాత్రం రోల్ మోడల్ జీవికే రామారావు గారండి. సో దిస్ ఈస్ ది బార్, నర్స్పూర్ బార్, which gave me the bread and butter when I was practicing in the High Court. And I am very much indebted to this bar. ఈ బారు రుణం అండి ఎప్పటికీ నేను తీర్చుకోలేని రుణం. ఈ స్థితిలో నేను ఉన్నానంటే కారణం ఈ బారే అని నేను చెప్పగలను. సభకు నమస్కారం. ఎంతోమంది ప్రతిభావంతులైన న్యాయమూర్తులను, న్యాయవాదులను మన రాష్ట్ర న్యాయ వ్యవస్థకి ఇచ్చిన మహోన్నతమైన బార్ ఇది నర్సాపూర్ బార్. ముందుగా నర్సాపూర్ బార్ అసోసియేషన్కి శిరస్సు వంచి నమస్కారం చేసుకుంటూ, ఏపీ బార్ కౌన్సిల్ చైర్పర్సన్ శ్రీ గంటా రామారావు గారు, సహచర న్యాయమూర్తులు, సీనియర్ న్యాయవాదులు, వేదిక పైన సభలోనున్న పెద్దలందరికీ కూడా పేరు పేరున నమస్కారాలు తెలియజేసుకుంటూ, ప్రేమాభిమానాలు, పచ్చటి ఆహ్లాదకరమైన వాతావరణానికి, మంచి మనసున్న మనుషులకు చిరునామా మన గోదావరి జిల్లాలో. ఇటువంటి చోట పుట్టడం అనేది అదృష్టం, పూర్వజన్మ సుకృతం అండి మనందరికీ కూడా. చాలా గర్విస్తాం కదండి ఒక మాట అంటే, ఎవరైనా గోదావరి అంటే. జ్యుడిషియల్ ఆఫీసెస్లోనండి ఒక నానుడు ఉంది, సివిల్ వర్క్ నేర్చుకోవాలంటే గోదావరి జిల్లాలో తప్పనిసరిగా పనిచేయాలి అని. అది మన న్యాయవాదుల ప్రతిభా గొప్పదనం అది. I became judge a decade back in 2013. What I have observed in this long tenure is, ఎక్కడైతేనండి సీనియర్సు బార్లో ఉండి బార్ నడిపిస్తూ కోర్టుకు వస్తున్నారో అటువంటి బార్లన్నీ కూడా క్రమశిక్షణతో ఉన్నాయి. కాబట్టి మై హంబుల్ రిక్వెస్ట్ ఈజ్, ఓపికన్నంత వరకు కూడా ప్రాక్టీస్ చేసినా చేయకపోయినా సరే కనీసం బార్ అసోసియేషన్స్కి రండి. మీ గైడెన్సు ఒక్క న్యాయవాదులకే కాదు, న్యాయమూర్తులకు కూడా అవసరం. ఇది జరగాలంటే మనం ఏం చేయాలండి? జాతి సంపద వంటి వాళ్ళందరినీ కూడా మనందరం గౌరవంగా చూసుకోవాలి. అలానే కోర్టుల్లో కూడా మంచి వాతావరణం ఉండాలంటే అడ్వకేట్స్, జడ్జెస్ ఇద్దరు కూడా పరస్పర గౌరవంతో ఉండాలి ఇప్పుడు కూడానండి. మంచి వాతావరణం ఉంటే క్వాలిటీ జడ్జిమెంట్స్ వస్తాయి. మంచి వాతావరణం లేకపోతే వీ కాంట్ ఎక్స్పెక్ట్ క్వాలిటీ జడ్జిమెంట్స్. అంతేనండి, ఏకీభవిస్తారా? In fact, this wonderful program is intended for junior advocate, learned junior advocates. మీరు చేయవలసింది ఏంటంటే సీనియర్స్ని సీరియస్గా ఫాలో కండి, అంతే. అది చాలు మనకి. అలాగేనండి, వృత్తిలో పైకి రావాలంటే విజయవంతంగా మనకి రెండు కళలు తెలిసి ఉండాలి ముందుగా. ఒకటేంటంటే బాగా ఆర్గ్యూ చేయగలగడం ఎంఫటికల్లీ. రెండోది ఏంటంటే సందర్భానుసారంగా నిశ్శబ్దంగా కూడా ఉండగలగడం. కొన్నిసార్లు ఎక్కువ మాట్లాడితే మనకి నెగిటివ్ వస్తుందండి. ప్రాక్టికల్గా మీ అందరికీ తెలిసిన విషయం అదంతా కూడానండి. రెండో విషయం ఏంటంటే, ఈవెన్ ఇఫ్ యు ఆర్ ఆస్క్డ్ టు టేక్ అడ్జార్న్మెంట్, రా జూనియర్స్ ఐఎమ్ టెలింగ్, ఈవెన్ ఇఫ్ యు ఆర్ ఆస్క్డ్ టు టేక్ అడ్జార్న్మెంట్ బై ది లెర్నడ్ సీనియర్ కౌన్సిల్, లెర్నడ్ సీనియర్స్, please do not go to the court without having basic facts on your hand. Please open the files and read the file once, because the concerned presiding officer may or may not grant you the time. If you ask a question, what is the matter about? Blank face చూపించకూడదు కదండి, because we cannot afford to lose our reputation and impression before the officers. అలానే లా బుక్స్ ఒకటి మాత్రం చదివితే మాత్రం సరిపోదండి. సక్సెస్ఫుల్గా మనం ముందుకు వెళ్ళాలి అంటే ఒక లా బుక్సే కాదు మనకు కావాల్సింది. జనరల్ నాలెడ్జ్, హిస్టరీ, వ్యవస్థలో ఉన్న లోపాలు, వ్యవస్థ ఎలా పనిచేస్తుంది, ఇవన్నీ కూడా అడ్వకేట్కి తెలియాలి తప్పనిసరిగా సక్సెస్ఫుల్ అడ్వకేట్గా మారాలి అంటే. అలానే మన వ్యవస్థలో పనిచేస్తున్న అందరికీ ఉండవలసిన క్వాలిటీ అండి, నాట్ ఓన్లీ ప్రాపర్ కోఆర్డినేషన్ బిట్వీన్ బార్ అండ్ బెంచ్, ప్రాపర్ కోఆర్డినేషన్ బిట్వీన్ బ్రెయిన్ అండ్ హార్ట్ ఆల్సో. వి షుడ్ హ్యావ్ దట్. అసలు ఒక లాయర్ ఎలాగ ఉండాలి? మాకు ఒక సీనియర్ ఉండేవారండి హైకోర్టులో, ఆయన చెప్తూ ఉండేవారు, ఒక లాయర్ ఎలా ఉండాలి. అసలు ఒక లాయర్ ఎలా ఉండాలంటే, సహనంలో, పేషెన్స్లో మహాత్మా గాంధీలా ఉండండి. అలానే విజ్ఞానంలో డాక్టర్ బిఆర్ అంబేద్కర్లా ఉండండి. 3 ధైర్య సాహసాల్లో అల్లూరు సీతారామరాజులుగా ఒక ప్రకాశం పంతులు గారిలా ఉండాలని చెప్పేవారు ఆయన. కమింగ్ టు టుడేస్ వండర్ఫుల్ ఈవెంట్, ది టాపిక్స్ కలెక్టెడ్: the constitutional protection under Article 20 of the Constitution of India. Second one is standards of legal profession. Third one is civil procedure code. These are undoubtedly all of us know. చాలా ఇంపార్టెంట్ టాపిక్స్ అండి ఇవన్నీ కూడా. I request all of you to listen to the dynamic judges of our High Court. Our administrative judge, Sri Rai గారి గురించి మీ అందరికీ తెలిసిందే. ఈజ్ ఎ వెరీ గుడ్ ఆరేటర్, నాట్ ఓన్లీ జూరిస్ట్, వెరీ గుడ్ ఆరేటర్ ఆల్సో. అండ్ యూ విల్ సీ అబౌట్ ఆర్టికల్ 20 హౌ హీ ఎక్స్ప్లెయిన్స్. అండ్ జయసూరి గారు అండ్ సుబ్బారెడ్డి గారు, వారు మన జిల్లాకి సూర్యచంద్రులు లాంటి వాళ్ళు అందరూ కూడా, మన భవిష్యత్ వాళ్ళు మన జిల్లాకి. And finally, we are very much indebted to the Bar Council of Andhra Pradesh and its members. Chairman garu Ramarao garu, Ramareddy garu, Krishnareddy garu, alage Chidambaram garu, for arranging this wonderful program. Now let us have hear our resource persons, our learned judges. I am sure that after conclusion of this wonderful event, all of you will leave the hall with complete satisfaction. Thank you very much. Thank you one and all. Jai Hind.
థ్యాంక్ యూ సార్. మనం అందరం కూడా నేర్చుకోవాల్సింది ఒకటి ఉంది. నేను హైకోర్టులో ప్రాక్టీస్ చేస్తున్నప్పుడు ఐ హ్యావ్ అడ్వాంటేజ్ ఆఫ్ సీయింగ్ ది ఎంట్రీ ఆఫ్ జస్టిస్ శేషాయ్ గారు. ఐ హ్యావ్ అడ్వాంటేజ్ ఆఫ్ అబ్జర్వింగ్ వెన్ మై లార్డ్ బికమ్ జడ్జి ఆఫ్ ది హైకోర్ట్. ఆ ఎంట్రీ రోజు ఎలా ఉన్నారో ఈరోజు కూడా అలానే ఉన్నారు. ఏం మాత్రం మార్పు లేదు. ఎదిగే కొంది ఒదిగి ఉండమంటాం, అలాంటి వారిని చూసి చెప్పుంటారు మన పెద్దలు. ఈ టైం మేనేజ్మెంట్లో తొందరగా నేను కొన్ని తప్పులు కూడా చేస్తున్నాను, మీరు అందరూ భరించాలి. రామిరెడ్డి గారు ఆల్ ద వే వేరే ప్రోగ్రాంలో ఉండి వచ్చారు. వారు 2 నిమిషాలు వారి మెసేజ్ ఇస్తారని ఆశిస్తాను.
Respected Chairman Bar Council of Andhra Pradesh, today's President Ramarao garu, Honorable Judge Chief Guest of the function Justice A.V. Sheshai garu, Administrative Judge Justice Manavendra Rai garu, Honorable Judges Subbareddy garu, Jayasuri garu, son of the sons of the Godavari districts, and the Principal District Judge Purushottam Kumar garu, my colleague friends Chidambaram garu and B.V. Krishnareddy garu, President of the Bar Association Narsapuram Palakol Subbarao Satyanarayana garu, President of the Honorable Judicial Officers, my colleague Bar Council member Chandrasekhar Reddy Madhavi garu, senior and junior brother and sister advocates of this function. మా చైర్మన్ గారు 2 నిమిషాలు టైం ఇచ్చారు కాబట్టి యాక్చువల్గా 1 డే ప్రోగ్రాంలో మనం చెప్పేది కంటే వినేదే ఎక్కువగా ఉంటుంది కాబట్టి మనం వినాలి. అందుకోసం క్లుప్తంగా 2 నిమిషాలు. నిజంగా వండర్ఫుల్ ప్రోగ్రామ్. 2013 నుంచి కూడా శేషయ్య గారు బార్ కౌన్సిల్ ఆఫ్ ఆంధ్రప్రదేశ్కి ప్రతి ప్రోగ్రామ్కి మాకు గెస్ట్గా వస్తున్నాడు. కంబైన్డ్ స్టేట్లో చాలాసార్లు ఆయన స్పీచ్ వినడం మా అదృష్టం. ఈ రోజు వరకు 2013 నుంచి ఈ రోజు వరకు కూడా రామారావు చెప్పినట్టుగా ఎప్పుడు ఒకే విధంగా అప్పటికి ఇప్పటికి చేంజెస్ లేకోకుండా చెప్పడము, మేము వినడము మా నిజంగా ఆయన నుంచి చాలా నేర్చుకున్నామని గర్వంగా తెలియజేసుకుంటున్నాం సార్. మరి రాయ్ గారు ఫస్ట్ అడిషనల్ డిస్ట్రిక్ట్ జడ్జిగా మా అనంతపురంలో అపాయింట్ అయినప్పుడు ఆయన నుంచి మేము ఉన్నది కొద్ది నెలలు అయినా కూడా 3 నెలల్లో మేము చాలా నేర్చుకున్నాం. ఆయన చాలా వరకు ఆ క్రిమినల్ సైడ్ బాగా చెప్పించిన వ్యక్తి. మేము అప్పటికీ మా జిల్లాగా వారిని రాయగారిని మర్చిపోలేం సార్. తర్వాత నర్సాపురానికి నేను రెండోసారి రావడం, ఫస్ట్ టైం సెమినార్లో పార్టిసిపేట్, ఇది సెకండ్ టైం. బార్ కౌన్సిల్ ఆఫ్ ఇండియా తరఫున నిజంగా ప్రోగ్రామ్ చేసి చాలా రోజులు అయింది. కరోనా పీరియడ్లో చేయాలనుకున్నాం, స్టేట్ ప్రోగ్రామ్ చేయలేకపోయినాం. తర్వాత ఈ నెల ఫిబ్రవరి 25 తేదీన జాయింట్ మీటింగ్ ఒకటి ఈ కొలిజియం సిస్టమ్ పైన బార్ కౌన్సిల్ చైర్మన్, వైస్ చైర్మన్, సీనియర్ జడ్జెస్ ఆఫ్ ది హైకోర్ట్ అండ్ సుప్రీం కోర్ట్ అండ్ ఫార్మర్ జడ్జెస్ ఆఫ్ ది హైకోర్ట్, సుప్రీం కోర్ట్ అండ్ సీనియర్ అడ్వకేట్ ఆఫ్ ది ఎంటైర్ కంట్రీ, నియర్లీ 5,000 మెంబర్స్ ఒక జాయింట్ మీటింగ్ పెట్టాలనుకున్నాము. అది ఈ నెల ఫిబ్రవరి 25 జరుగుతుంది. దేశంలో ఉన్నటువంటి ఈ రిఫ్లిక్ట్ అంతా స్పెసిఫై చేయడానికి ఒక స్టెప్ ముందుకు రావాలని బార్ కౌన్సిల్ ఆఫ్ ఇండియా పోయిన వారమే నిర్ణయం తీసుకోవడం జరిగింది. అదేవిధంగా ఈ కేసులు డిస్పోజ్ కావడానికి ఏడిఆర్ సబ్జెక్ట్ని బార్ కౌన్సిల్ ఆఫ్ ఇండియా ప్రవేశపెట్టింది. అన్ని లా కాలేజీలో ఒక సబ్జెక్టుగా ఏడిఆర్ని పెట్టి డిస్పోజ్ ఆఫ్ ది కేసెస్ స్పీడ్ చేయాలని ఒక సబ్జెక్ట్ పెట్టింది అన్ని కాలేజీలో కూడా లాస్ట్ నుంచి. అంతేకాకుండా అడ్వకేట్స్ అకాడమీ, లా టీచర్స్ అకాడమీ కూడా ఒక స్టార్ట్ చేయాలని భువనేశ్వర్లో లా టీచర్ అకాడమీ ఫౌండేషన్ పడింది. కన్స్ట్రక్షన్ ఈజ్ గోయింగ్ ఆన్. తర్వాత అడ్వకేట్స్ అకాడమీ గోవాలో ఇంటర్నేషనల్ లా స్కూల్ ఆఫ్ ఇండియా ఒకటి స్టార్ట్ చేసాం ఈ ఇయర్ నుంచినే. అక్కడ ఒక అడ్వకేట్స్ అకాడమీ కూడా ఎంటైర్ కంట్రీకి ఉండాలని, ఇంటర్నేషనల్ స్టాండర్డ్ లెవెల్లో పెట్టాలని అది కూడా స్టార్ట్ జరగబోతుంది. కాలేజ్ స్టార్ట్ అయింది, అడ్వకేట్స్ అకాడమీ తొందరలో స్టార్ట్ అవుతుంది. దానికి హానరబుల్ జస్టిస్ పిఎస్ నరసింహ గారు ఛాన్సలర్గా ఉన్నారు, సుప్రీంకోర్టు జడ్జి. మిగతా జడ్జెస్ అందరూ కూడా జస్టిస్ గవాయ్ గారు, జస్టిస్ సూర్యకాంత్ గారు మెంబర్లుగా ఉన్నారు అందులో. అంతేకాకుండా ఇంకా ఈ డిసిప్లినరీ కేసెస్ చాలా ఇందాక చెప్పాడు, ఈరోజు ఎథిక్స్ ఆఫ్ ప్రొఫెషనల్ ఎథిక్స్ ఆఫ్ అడ్వకేట్స్, దీంట్లో చాలామంది తెలియని తప్పులు చేసుకుంటూ ఆ క్లయింట్లతో ఆ బిహేవియర్ లేకుండా చిన్న తప్పులు కూడా కేసులు బార్ కౌన్సిల్ రావడము. బార్ కౌన్సిల్లో సెక్షన్ 35 ప్రకారం అడ్వకేట్స్ 1 ఇయర్లో డిస్పోజ్ కాకపోతే అవి బీసీఐకి ట్రాన్స్ఫర్ కావడము. అక్కడ పెండింగ్లో ఉండి దాదాపు ఇప్పటికీ ఒక 4,000 కేసులు బార్ కౌన్సిల్ పెండింగ్ ఉంటే హానరబుల్ సుప్రీంకోర్టు జడ్జెస్ మన ఒక జడ్జిమెంట్ ఇస్తూ ఈ నెల 15 లోపల డిస్పోజ్ చేయమని చెప్పింది. దానికి సర్క్యూట్ బెంచెస్ అన్ని వేసి ఎంటైర్ కంట్రీలో ఆల్మోస్ట్ 95% కేసు డిస్పోజ్ చేయ జరిగింది. ఒక ఆంధ్రప్రదేశ్ మాత్రమే ఒక 70 కేసెస్ పెండింగ్ ఉన్నాయి. ఆ కేసు కూడా ఈ నెలాఖరు కానీ లేదా మార్చి 2nd వీక్ లోపల డిస్పోజ్ అవ్వడానికి అవకాశం ఉంటుంది. ఓన్లీ 70 అది ట్రాన్స్ఫర్ కేసెస్ బార్ కౌన్సిల్ ఆఫ్ ఇండియాలో ఆ కేసులు అన్నీ కూడా ఉంటాయి. అవన్నింటిలో తొందరగా ఇన్ఫార్మ్ చేస్తాం. చైర్మన్ గారు మిగతా మెంబర్స్ అంతా కలుసుకొని అది ఇక్కడే విజయవాడ లేదా విశాఖపట్నంలోనే సర్క్యూట్ బెంచ్ చేసి ఢిల్లీ కాకుండా అడ్వకేట్లకు ఒక కన్వీన్స్ కోసం ఇక్కడే సర్క్యూట్ బెంచ్ స్టార్ట్ చేసి డిస్పోజ్ చేస్తామని తెలియజేసుకుంటున్నాను. ఇంకా అడ్వకేట్స్ ప్రొటెక్షన్ యాక్ట్ అని చాలా రోజు పెండింగ్లో ఉంది. అందులో నేను కమిటీ మెంబర్గా ఉన్నాను. ఆ రిపోర్ట్ కూడా సబ్మిట్ జరిగింది 5 మంది కమిటీలో. అడ్వకేట్ ప్రొటెక్షన్ యాక్ట్ అది కూడా గవర్నమెంట్ ఆఫ్ ఇండియా దగ్గర పెండింగ్లో ఉంది. దాని నుంచి కూడా పర్సూ చేస్తున్నాము. ఇంకా ఇందాక చెప్పినట్టు ఇన్సూరెన్స్ గురించి అనుకున్నప్పటికీ దేశవ్యాప్తంగా ఇన్సూరెన్స్ కావాలని ప్రెసిడెంట్ ఆఫ్ ఇండియా రిక్వెస్ట్ చేయడం జరిగింది. ఒక 1,000 కోట్ల రూపాయలు బడ్జెట్లో కేటాయిస్తే ఎంటైర్ కంట్రీ ఇన్సూరెన్స్ ఏర్పాటు చేసే అవకాశం ఉంటుందని ఆ రిప్రజెంటేటివ్ పెండింగ్ ఉంది. ఒక డిమాండ్గా పెట్టినాం దాన్ని. తొందరలో అది కూడా సక్సెస్ అయితే దేశంలో న్యాయవాదులందరికీ కూడా మంచి ఉపయోగము. ఇన్సూరెన్స్ లేకోకుండా ఈ ప్రజెంట్ కార్పొరేట్ సెక్టర్లో వీ కెనాట్ ఏబుల్ టు సీ అడ్వకేట్స్ అందరూ కూడా. అందువల్ల అది వెరీ ఇంపార్టెంట్ ఫ్యాక్టర్ అని తెలియజేసుకుంటున్నాం. ఇక సెమినార్ల విషయంకి వచ్చేటప్పటికి డిస్ట్రిక్ట్ ఒకటి పెట్టుకోవడం, నిజంగా మా జడ్జెస్ ఇంత బిజీ షెడ్యూల్లో కూడా వాళ్ళు రావడము, ఈ ప్రోగ్రామ్ సక్సెస్ చేయడము, వారందరికీ కూడా మనం ప్రత్యేక ధన్యవాదాలు చేసుకోవాలా. మనం చాలామంది సెమినార్లు అంటే ఏముంటుందిలే అనుకుంటాం, కానీ ప్రతి సెమినారు, ప్రతి మీటింగు, అడ్వకేట్ ఇందులో ప్రతి వ్యక్తిలో కొన్ని గుణగాలు మనం తెలుసుకోగలిగితే మనం దాంట్లోనే సంపాదించుకోగలిసినంత జ్ఞాన సంపాదన వస్తుంది. సీనియర్లు అన్నట్టు సీనియర్ న్యాయవాదులు లేకుండా అది బార్ అసోసియేషనే కాదు, సీనియర్లకు మనం జూనియర్లకు గౌరవించుకోవాలా. జూనియర్లు కూడా ప్రజెంట్ డేస్లో చదువుకుంటూనే వెంటనే వచ్చేసి నేనే స్వతంత్రంగా చేయగలను అంటున్నారు. అది మంచి పద్ధతి కాదు. ఖచ్చితంగా 1 year అయినా కానీ సీనియర్ దగ్గరికి వెళ్ళాలి, మెలకువలు తెలుసుకోవాలి. ఆ ప్రొసీజర్స్ అట్లీస్ట్ బార్ అసోసియేషన్ సాంప్రదాయాలు తెలుసుకోగలిగితే ఆ బార్ అసోసియేషన్ దిగ్విజయంగా చేయడానికి అవకాశం ఉంటుంది. పాత ప్రొసీజర్ని మనం అదే విధంగా మెయింటైన్ చేసుకున్నప్పుడే బెంచ్ అండ్ బార్ బాగుంటుంది. ఆ బెంచ్ అండ్ బాగున్నప్పుడే మనం నిజంగా కక్షిదారులకు న్యాయం చేస్తామని తెలియజేసుకుంటూ ఇటువంటి అవకాశాలు కల్పించినటువంటి బార్ ప్రెసిడెంట్కి, బార్ అసోసియేషన్, బార్ కౌన్సిల్ మెంబర్కు, ఇక్కడ ఇచ్చేటువంటి న్యాయమూర్తులు అందరికీ మరోసారి కృతజ్ఞత చేసుకుంటూ, ముఖ్యంగా చిదంబరం వారికి కూడా నా ధన్యవాదాలు చేసుకుంటూ సెలవు తీసుకుంటాం. థ్యాంక్ యూ వెరీ మచ్.
కృష్ణారెడ్డి గారు, నాట్ ఇన్ ద ఫార్మ్ ఆఫ్ స్పీచ్ బట్ అ మెసేజ్.
అందరికీ నమస్కారం. పశ్చిమ గోదావరి జిల్లా ముద్దుబిడ్డ చీఫ్ గెస్ట్ ఆకుల వెంకట శేషాయి గారికి, అలాగే పశ్చిమ గోదావరి జిల్లా అడ్మినిస్ట్రేటివ్ జడ్జి చీకటి మానవేంద్రరాయ్ గారికి, అలాగే పశ్చిమ గోదావరి జిల్లా ముద్దుబిడ్డ నైనాల జయసూర్య గారికి, అలాగే పశ్చిమ గోదావరి జిల్లా ముద్దుబిడ్డ సత్తి సుబ్బారెడ్డి గారికి, మన బార్ కౌన్సిల్ చైర్మన్ గంటా రామారావు గారికి, అనంతపూర్ నుంచి చాలా బిజీగా ఉండి ఇక్కడికి వచ్చిన అల్లూరు రామరెడ్డి గారికి, మన ప్రిన్సిపల్ డిస్ట్రిక్ట్ జడ్జ్ చింతలపూడి పురుషోత్తం కుమార్ గారికి, అలాగే ఇంతటి అద్భుతమైన సెమినార్ని ఒక ఉపయోగకరమైంది ఏర్పాటు చేసిన కీ మ్యాన్ మన చిదంబరం గారు, ఆయన వెనకమాలుండి నడిపించిన పాలకొల్లు బార్ అసోసియేషన్, అలాగే నర్సాపురం బార్ అసోసియేషన్ ప్రెసిడెంట్ గారికి, మెంబర్స్ అందరికీ పేరు పేరున ధన్యవాదాలు, నమస్కారం తెలియజేస్తున్నాను. ఈ నర్సాపురం బార్ అంటేనే 100 years సెంచరీ, ఇక్కడ 100 year ఫంక్షన్కి నేను ఇక్కడికి రావటం జరిగింది. ఇది ఒక అద్భుతమైన ఒక బార్ అసోసియేషన్. దీని పేరు తలుసుకుంటేనే ఎప్పుడు నేను ప్రాక్టీస్కి వచ్చి 37 సంవత్సరాలు అయింది. ఎప్పుడు మేము ఎప్పుడు చూసినా ఓన్లీ నర్సాపురం భీమవరం వారే మాకు హైకోర్టు జడ్జెస్గా ఉండేవారు. ఇక్కడికి వచ్చిన తర్వాత వెళ్తూ ఏలూరు వచ్చి తప్పకుండా విజిట్ చేసి వెళ్తూ ఉండేవారు. ఇది చాలా చరిత్ర గల నర్సాపురం బార్ అసోసియేషన్. అద్భుతమైన జడ్జెస్ని, అద్భుతమైన లాయర్ని ప్రొడ్యూస్ చేసిన బార్ ఇది. ఎంతో దూరం నుంచి, నెల్లూరు నుంచి ఇక్కడికి వచ్చిన బార్ కౌన్సిల్ మెంబర్ మా చంద్రశేఖర్ రెడ్డి సార్ గారికి, అలాగే గుంటూరు నుంచి వచ్చిన రోళ్ల మాధవ్ గారికి ప్రత్యేక ధన్యవాదాలు. ముఖ్యంగా ఇప్పుడు ప్రజెంట్ ఇక్కడ ఈ సెమినార్ వక్తలైన లాస్ట్ టైం నవంబర్ 27న జరిగిన వన్ డే సెమినార్లో ఆ ప్రసంగించిన ప్రసంగానికి కొన్ని వందల మంది, వేల మంది అడ్వకేట్స్ అప్రిషియేట్ చేయటం జరిగింది. అప్పుడు మా సాయి గారు ఎంత గొప్పగా స్పీచ్, ఆయన చెప్పిన సివిల్ రూల్స్, సివిల్ ప్రాక్టీస్ ఎంతగానో అందరూ ఇదైంది. అలాగే సార్ మానవేంద్రరాయ్ సార్ 2 hours 10 minutes ఈ ఏజ్లో, ఇంత బిజీలో 2 hours 10 minutes అలా కనీసం మంచిలు తాకుండా ఆ సెమినారు పిన్ ఆఫ్ సైలెన్స్గా జరిపించి ఎంతో గొప్పగా నడిచింది. చాలామంది అప్రిషియేట్ చేయడం జరిగింది. మీకు నేను జడ్జెస్ నలుగురికి మీ టైం స్పెండ్ చేసి లాస్ట్ టైం అక్కడికి వచ్చినందుకు, ఇప్పుడు ఇక్కడికి వచ్చినందుకు ప్రత్యేక ధన్యవాదాలు తెలియజేసుకుంటున్నాను సార్. అలాగే ఇప్పుడు ప్రజెంట్ కరెంట్ సిచ్యువేషన్ ఏంటంటే సుప్రీంకోర్టు కొలీజియంలో గవర్నమెంట్ ఇంటర్ఫీరెన్స్ అనేది కరెంటు ఎఫ్ఐఆర్గా నడుస్తుంది. అది ఎంతవరకు సబబు, ఎంతవరకు కాదు అనేది ఆల్రెడీ సుప్రీంకోర్టు కొలీజియం రికమెండ్ చేసి పంపించిన నేమ్స్ కూడా అక్కడ పెట్టి గవర్నమెంటు ఇంకా ఇచ్చేస్తుంది అంటే అది ఎంత డిబేటబుల్ ఇష్యూ అనేది ఒక్కసారి మీరందరూ ఆలోచించవలసిందిగా కోరుతున్నాను. గవర్నమెంట్ వాంటెడ్ టు ఇంటర్ఫియర్ విత్ ది కొలీజియం. దిస్ ఈజ్ నాట్ ఏ గుడ్ థింగ్. మై ఒపీనియన్, collegium is collegium, judiciary is independent, దాంట్లో ఎవరి ప్రమేయం ఉండకూడదనేది నా అభిప్రాయం. కాబట్టి ఇంత మంచి సెమినార్లో యాక్చువల్గా ఇక్కడ తీసుకున్న సబ్జెక్టు హైకోర్టులో చేస్తే బాగుండేదని నేను మా వాళ్ళందరికీ చెప్పడం జరిగింది. కానీ ఇక్కడ జరిగేదంతా హైకోర్టు వారు అబ్జర్వ్ చేస్తారు, వాళ్ళు చూస్తూ ఉన్నారు, మళ్ళీ కూడా చూసుకుంటారు. కాబట్టి ఈ సమావేశాన్ని ఏర్పాటు చేసిన ముఖ్యంగా నర్సాపురం అండ్ పాలకొల్లు బార్ అసోసియేషన్ వారికి ప్రత్యేక ధన్యవాదాలు, థ్యాంక్స్ చెప్పుకుంటూ నాకు ఈ అవకాశం ఇచ్చిన బార్ కౌన్సిల్ చైర్మన్ గారికి థ్యాంక్ యూ వెరీ మచ్. నమస్తే.
Thank you, sir. Now we will be continuing with the first session. The constitutional protection provided in the field of criminal law under Article 20 of the Constitution of India, overall view by my Lord Justice Chekiti Marvendranath గారు. ఇందాక మనం ఒక విధమైన యాంగిల్ శేషాయి గారిలో చూస్తే ఇంకొక రకమైన యాంగిల్ మానవేంద్రనాథ్ రాయ్ గారు, ఎందుకంటే అథారిటేటివ్ ఆ సబ్జెక్ట్లో మరి అటు అడ్వకేట్గా ఉన్నప్పుడు కూడా అటు జడ్జిగా ఉన్నప్పుడు కానీ రెండో ఇది లేకుండా అంతటి అథారిటేటివ్గా ఉంటమే కాకుండా వారు సంపాదించినటువంటి ఆ జ్ఞానాన్ని మనందరికీ కూడా సింప్లిఫై చేసి అర్థం చేసుకునే విధంగా చెప్పడం చాలా గొప్ప విషయం. నవ్ ఐ కాల్ అపాన్ మై లార్డ్ జస్టిస్ మానవేంద్రనాథ్ రాయ్ గారు టు డెలివర్ హిస్ లెక్చర్.
President of today's function, Sri Ganta Ramarao Garu, Chairman of Bar Council of State of Andhra Pradesh, my esteemed brother judges, Justice A.V. Sheshai Garu, Justice Jayasurya Garu, and Justice Subbareddy Garu, Principal District Judge of West Godavari District, Mr. Purushottam, members of the Bar Council on the dais and off the dais, presidents of the Narsapuram Bar Association and Palakollu Bar Association, senior advocates present here, judicial officers, advocates from High Court, ladies and gentlemen, a very good morning to you all. Before I start interacting on the topic assigned to me, let me first express my feelings. I really feel highly delighted and in fact elated, and also as my proud privilege to be amongst you all today morning in this Narsapuram town and on the floor of this Narsapuram town. The obvious reason is the reputation which this Narsapuram Bar Association got in the annals of state judiciary. One of the ancient bar associations in the entire command state of Andhra Pradesh, known for its legal acumen and the high ethical standards they have set in the legal profession. I used to hear high of this bar association in the legal circles, even when I was an advocate, from the advocates, from some of the judicial officers, and also even after I entered the service, judicial service, from various judges and judicial officers. And I was eagerly waiting for an opportunity to visit this Narsapuram Bar Association, and when the Mr. Ramarao and the son of your soil, Chidambaram garu, approached me with a request to participate in this seminar, without any hesitation, I immediately grabbed but I have given only an overview, that is only a summary. It is not possible to discuss relating the overall view of the concept of section 20 in this 1.5 hour session. So I have given only an overview, that is a summary of that concept only. Now Article 20 is part 3 of our Constitution. Part 3 of our Constitution deals with of the fundamental rights. So Article 20 itself is a fundamental right conferred on the citizens of this country. Now what is this 20? Article 20, this Article 20 deals with 3 important doctrines. It contains clause 1, 2 and 3. It deals with 3 important doctrines, namely, first one, ex post facto law, that is clause 1. Second one, clause 2, deals with the Jabal Dia Pade. And third one, clause 3, deals with testimonial compulsion, which is also called as principle of self-incrimination. These are the 3 doctrines with which section 20 deals with. Now, Article 20, clause 1, ex post facto law, again is in 2 parts. The first part, just for the benefit of you all, let me read section 20, clause 1 for your understanding. Clause 1 of 20. No person shall be convicted of any offence except for violation of law in force at the time of the commission of the act charged as an offence, nor be subjected to penalty greater than that which might have been inflicted under the law in force at the time of commission of the offence. So it deals with the punishment to imposed against that person who was prosecuted. Now to elaborate more precisely, the first part says that only a person can be prosecuted for an act done or an omission made by him if it was an offence when that act was committed or that omission was made. When there was no law punishing that act itself, when it was committed, he is not liable for prosecution. Suppose today an act was committed. Today we are 4th February. An act or omission was committed by a person. That was not an offence either under any of the provisions of the Indian Penal Code or under any of the provisions of the special enactments or the state laws or the central laws. So he is not liable to be prosecuted for that act or omission. Now subsequently, tomorrow, in the month of March, again after 1 month, an act was brought making that act which was earlier committed or omission an offence. Now you cannot prosecute this person for the act committed by him earlier on the basis of the subsequent enactment. In other words, any act that is brought into making a certain act an offence cannot be given a retrospective effect. It must only prospectively operate, not with retrospective effect. If it is given a retrospective effect, it would be hit by this ex post facto law under part 1 of Article 20, clause 1 of Constitution. Then the second part also related to punishment. Suppose today an act was committed which is an offence according to the law which is now in force. Now the prescribed punishment for that act is 1 year today. Now after 1 month or 2 months or 1 year, it was amended, act was amended, enhancing the punishment. Now by the time of that amendment, still the trial is going on. The offence was committed today and he is being prosecuted. the punishment prescribed is 1 year today. Now after 1 year, it was amended, enhancing the punishment to 3 years. By that time, the trial is not concluded, it is pending. Now the question is whether that a person can be convicted for a period of 3 years as per the enhanced sentence by way of amendment that was brought into the enactment. The part 2 of the Article 21 says that it cannot be. Even for punishment also, the person is liable to be punished only as per the punishment prescribed when that act was or offence was committed. Even if subsequently it was enhanced, even during the course of the trial of that case, he cannot be imposed a sentence more than the one which was prescribed at the time of the commission of the offence. That is the second part of the Article 20, Clause 1. So these are the two parts contained in the first Clause 1 of Section 20, which is dealing with ex post facto law. Now the question may arise that suppose if the now punishment is 1 year today for the offence that was committed now. Suppose subsequently by way of amendment the sentence is reduced from 1 year to 6 months, then whether the accused is entitled to that benefit or not, or whether it is also hit by the ex post facto law. The interpretation given is that for that the accused is entitled. See, what is prohibited under Article 20, Clause 2 is it cannot be enhanced, but there is no prohibition to reduce the sentence. So the Supreme Court, when the question came up before the Supreme Court, so when there is a prohibition to enhance the sentence, how can the accused can take benefit of reduction of the sentence? Supreme Court said that a beneficial interpretation is to be given, a provision which is disadvantage to the accused that is prohibited, but a provision which is advantageous to the accused is not prohibited under Article 20, Clause 1, Subclause 2. That was the law decided on this aspect. Now, on this Article 20 relating to the doctrine of ex post facto law, the law has been tremendously developed from 1950 onwards. There are various cases which are very much interesting, which require to be placed before you for our discussion. Now, for example, criminal liability and civil liability, an act is there. It imposes both criminal liability and civil liability on a person. Now, whether this civil liability also is attracted by Article 20, Clause 1 is the question first arose before the Supreme Court. It was a case where there was a tax due for the panchayat. Now, for the non-payment of tax imposes a civil liability for which a defaulter is liable for initiation of proceeding for recovery of that tax dues. Now, subsequently, the same was also made punishable. Committing default in payment of panchayat dues is also made a criminal offence subsequently. This was challenged before the Supreme Court. That was in the case of 1967, before the Kerala High Court it has first come, 1967 Kerala 155, Parid versus Nilambram. In that case, the facts are like this. For non-payment of the panchayat dues was not an offence on the day when it fell due. The defaulter, it is held that defaulter cannot be convicted for his omission to pay under law enacted subsequently, even if it is covered, it covers earlier dues. So, when the act committed by a person attracts both civil liability and criminal liability, the the arrears of the panchayat that was fell due to the panchayat can be recovered by taking recourse to the civil liability. But so far as the subsequent law that is made, making it an offence, cannot be made applicable for the tax which was due prior to its enactment. That is the law laid down in this case. Then, this ex post law is concerned, an interesting case is relating to this section 304B, dowry death case. See, this dowry death case was subsequently introduced in our IPC in the year 1986, November. Earlier, we have only an offence under 498A. Then subsequently, this 304B was introduced. It came into force in the month of November 1986. Now, the question arose whether the dowry death took place prior to November 1986. A person can also be prosecuted and convicted under section 304B or not. Then this was challenged on the ground of ex post facto law. So, only a dowry death that took place from the month of November 1986 only is liable for prosecution and conviction. This 304B amendment cannot be applied to the acts that were committed earlier to November 1986. This was decided in AR 1991 Supreme Court 2173. That is the case of Devaranjan Bahubai versus State of Gujarat. So this is the classic example dealing with this ex post facto law. Then, recently we have discussed that when the same act imposes both civil liability and criminal liability, it is only criminal liability that is hit by Article 20 and not the civil liability. There was an interesting case in this regard. In one case, a lockdown was declared, a closure was declared of the industry. So all the employees working in that industry became unemployed. They were deprived of their unemployment. Now this closure was declared in the year 1946 June. Now, as on the date of closure of that industry, the act of illegal closure of the industry was not made an offence in 1946. So the management has declared closure of the industry. That was not an offence in the year 1946. Now in the year 1947, an act was brought into existence, making an illegal closure of industry an offence. Now, along with in the same act, they also impose the civil liability on the management to pay compensation to the employees who lost their employment on account of illegal closure of that industry. Now, this enactment was brought in 1947. This was challenged in the court on the ground of this ex post facto law, hit by ex post facto law. So, the act imposes two liabilities. One is criminal liability, one is civil liability. Criminal liability is that is liable for prosecution and punishment for 1 year or 2 years for declaring or making illegal closure of the house. Simultaneously, it also imposes the civil liability to pay compensation to the employees who lost their employment on account of this illegal closure of the unit. Now, when the matter was, the enactment was challenged, the court has upheld the civil liability even with retrospective effect. But the court has struck down the criminal liability applying this ex post facto law. So he is not liable now for prosecution and punishment for closure of the industry illegally, but he is liable to pay compensation for illegal closure of the industry. This is the very interesting case that was decided in Hatsing Manufacturing Company versus Union of India, reported in AR 1960, 923. So this judgment, these facts of this case and the decision given in this case gives a clarity how to decide whether a particular liability is civil liability or a criminal liability, whether it is hit by the ex post facto law under Article 20 Clause 1 or not. So ultimately the Supreme Court held in this, what is prohibited under Article 20 Clause 1 under the ex post facto law is only giving retrospect effect to the criminal liability, and it does not impose any prohibition relating to civil liability. That is the law laid down in this case, an interesting case which everyone can go through this judgment. Then it is interesting held like this in that judgment. The Act was passed in June 1957, imposed on employees closing the undertakings the liability to pay compensation to their employees since November 28, 1956. For failure to discharge the liability to pay compensation, a person could be imprisoned under the statute. The question was if the Act violated under Article 20 Clause 1. Here another interesting question is, while imposing the civil liability to pay the compensation, if you fail to pay the compensation, punishment is also prescribed there. Now that was also challenged, but Supreme Court upheld that. See, the basic liability is civil liability. For committing default of that liability, a punishment is imposed. So it is not hit by Article 20 Clause 1 ex post facto law. This is another interesting factor which is to be noted in this judgment. So a default, for a default committed in fulfilling the criminal civil liability, if a penalty or punishment is imposed, that is not hit by the ex post facto law, is the law laid down in this judgment by the Supreme Court in 1960. Now, likewise, the same another question arose before the Supreme Court is that when a tax is imposed under the tax laws, which is undoubtedly a civil liability, and if a punishment is prescribed for committing default in payment of tax with retrospective effect, because tax can be imposed with retrospective effect because it is not a criminal liability. So it is not hit by Article 20 Clause 1 under the principle of ex post facto law. But it was challenged that by imposing tax with retrospective effect, they have also prescribed punishment for committing default of the same. That was again questioned before the Supreme Court. The Supreme Court held that no, the basic liability, the test is whether the test to apply to see whether ex post facto law applies or not is to see what is the basic liability, whether the basic liability is the criminal liability or the civil liability. If it is the civil liability and if any penalty is imposed or a punishment imposed for violating that civil liability, then it is not hit by the principle of ex post facto law, is the principle laid down by the Supreme Court in this case also. That was decided in AR 1984 Supreme Court 1194. That is Sivadat Roy Fateh Chand versus Union of India. The Supreme Court held likewise a tax can be imposed retrospectively. Not only that, even a penalty under tax law imposed retrospectively does not violate Article 20 Clause 1 because the penalty is simply a civil liability to be enforced by the tax authorities. Okay. Now I think you got no clarity on this. So you have to see whether the basic liability that is imposed is civil liability or criminal liability. If it is simply a civil liability, even if any penalty or punishment is imposed to enforce that civil liability, that is not hit by the principle of ex post facto law, and only when the basic liability is criminal liability and that act is made an offense retrospectively, that is hit by the principle of ex post facto law. These are the two classic cases to be discussed on this ex post facto law. Directly on the criminal liability, this 304B is the better judgment. That is in Sajjan Singh's case. Then, next interesting question that arises is, there is a criminal liability, there is a criminal case. Now, an act was committed today. It was an offence as per the law in force as on today. Now he is being prosecuted. After 1 year, during the pendency of the trial, an amendment was brought, amending the form of trial of that case, or amending the rules of evidence to prove the offence against that accused. Now, whether this amendment relating to change of forum of the case or the change of rules of evidence is hit by the principle of ex post facto law or not, is the question. See, basically is that if an act is committed today, if it is not made an offence under the provisions of IPC or any special enactment, state laws or central laws, he cannot be prosecuted, he cannot be punished. By making a law subsequently with retrospective effect. That is the principle of ex post facto law. Suppose the act that was committed today is an offence according to the provisions of IPC or any special enactment. Now he is being prosecuted. So subsequently an amendment was brought changing the forum or the rules of evidence. So whether that is hit by ex post facto law or not. What do you say? Can anyone answer this? You can't answer. Huh? Not hit by? Forum can be changed. The accused contends that as per the law which is in force as on today. See, అందుకే అంటే I'll explain it. Okay. See, Article 20 లో చూస్తే మనం no person shall be convicted of any offence except for violation of law in force. Law in force at the time of commencement of the act. So, this act which was committed by me, okay, it is an offence as per the law in force as on that day, today. Therefore, I am entitled to be prosecuted only as per the evidence that was in force, rules of evidence that was in force on that day, or as per the forum which is prescribed for trial of that case as on that day. And he phrased that for violation of law in force, he has taken advantage of it. He says that when the same principle applies even to the rules of evidence and also to the forum of the to be tried. Then how do you decide? Okay, what is the reason for your contention that it applies? So, see, as of today, offence was committed today. Today it is triable by a judicial magistrate first class. Okay, after 6 months, an amendment was brought, constituting a special court. Now this was transferred to that court because of that amendment. Offence జరిగే నాటికి నాది నా ఫారం అది కాబట్టి నేను అక్కడే ఐ మస్ట్ బి ట్రైడ్ ఇన్ దట్ కోర్ట్ ఓన్లీ, నాట్ ఇన్ దిస్ కోర్ట్. దిస్ కోర్ట్ హ్యాస్ నో జ్యూరిస్డిక్షన్ అన్నాడు అనుకోండి. దెన్ బికాజ్ ఇట్ ఈస్ హిట్ బై దట్ ఎక్స్ పోస్ట్ ఫ్యాక్టో లా అని అన్నాడు అనుకోండి. అప్పుడు ఏంటి హౌ డూ యూ సపోర్ట్ యువర్ వెర్షన్ దట్ ఇట్ ఈస్ నాట్ హిట్ బై ఎక్స్ పోస్ట్ ఫ్యాక్టో లా అని? రీజన్ కావాలి నాకు. ఐ వాంట్ ది రీజన్. ఓకే, దెన్ ఫర్ వాట్ అబౌట్ రూల్స్ ఆఫ్ ఎవిడెన్స్? Okay, okay, good. Your answer is correct, but reason I will tell you. Your answer is correct. See, both forum also can be subsequently changed and rules of evidence also can be subsequently amended. They are not hit by the principle of ex post facto law, because the Supreme Court held that they deal only with the procedure in prosecuting the accused for that particular offence, whether by a particular forum or by applying particular set of rules of evidence. So both rules of evidence and also these forum relating to where he has to be tried are only procedural rights, and it will not be affected by this principle of ex post facto law. Is the ultimate decision that was taken by the apex court. That I will give you the judgment. In Sajjan Singh versus State of Punjab, AR 1964, page 464. It was also a case under the Prevention of Corruption Act, anti-corruption laws. There, some provision was subsequently incorporated in the Act pertaining to presumption under section 5(3). Now, the court can presume certain facts to be proved by under the 5 clause 3. This was challenged before the Supreme Court. Supreme Court said that it is not held by ex post facto law, because making an amendment relating rules of evidence at the forum where the trial has to take place are not prohibited under the ex post facto under Article 20, Clause 1. Now, just now we have discussed regarding law in force. Article 20, Clause 1 mandates that no person shall be convicted of any offence except for violation of law in force at the time of commencement of the act. So now law in force means, suppose subsequently an enactment was made, and it is said that suppose it was brought today on 4th February. Now it contains a provision saying that this act is deemed to have come into force on 4th February of 2022, last year. Now, by virtue of this deeming provision in this enactment, can you punish a person who has committed the offence in December 2022? Because prosecution says that the act is deemed to have come into force in the month of February 2022, even though it was enacted today. So it covers all the acts that were committed from February 2022 even till today and subsequently. What do you say? Deeming provision. Interesting question. Yes. Emma?
The person can't be punished. The person can't be punished for the recent amendment. Because by the time what was the act was that was in force, that is only applicable. The benefit should be given to the accused. So the latest law is not applicable.
So all of you are of view it is hit by ex post facto law, even though it contains a deeming provision, giving effect. మరి అదే కదా ఇచ్చారు ఇక్కడ మరి బై virtue of the deeming provision, in effect they have given a retroactive effect.
Then how do you say that? That enactment itself is hit by Article 20, sir.
Okay, yes. All of you are correct. Even though it contains a deeming provision, the Supreme Court held in effect it amounts to giving a retroactive effect to that enactment, because what was not an offence when it was committed, when an act was committed, cannot be made an offence by a subsequent enactment is the basic principle. Therefore, even if the act contains a deeming provision giving effect to that enactment to a prior date, then still it is hit by the principle of ex post facto law. That was decided in the, listen to this commentary, this was there. The law in force, the Supreme Court said, must be the law which was factually in operation on the date of commission of the offence, and not the law which by legal fiction is made operative by virtue of the powers of the legislature to pass actually in operation. The law must be factually in operation, not by way of giving a deeming fiction like this in a case which I have just now placed before you all. That was decided in Rao Saho Bahadur Singh versus State of VP, that is Vindhya Pradesh, in AIR 1953 Supreme Court 394 page. So with this, part 1, section 20 clause 1 contains two parts, ex post facto law. First one deals with making an act which was committed earlier, an offence subsequently by bringing an enactment with giving retrospective effect to it. It is hit by ex post facto law. No person is liable to be prosecuted or punished for that act, which was not an offence at the time when it was committed. That is one. Now, second part deals with imposition of punishment. Just before commencement of this discussion, we have discussed that punishment also is only liable to the punishment which is in force as on that day. Even if it is subsequently amended, he cannot be imposed with that punishment. Now, on that, part 2, the relevant case on this is Kedarnath Bhajoria versus State of West Bengal, AR 1953 Supreme Court 404, that was also. Here, as per the facts of this case, the offence was committed in the year 1947, under which the prescribed punishment is punishment for 1 month or fine or with both. Now, the act was later amended and the punishment prescribed was enhanced by a further fine to be equivalent to the amount of money found to have been procured by the offender through his offence. It was held that enhanced punishment prescribed by the amendment could not be applicable to the offence committed in 1947 because the prohibition contained in the later part of Article 20, Clause 1. However, it does not prohibit reduction of the penalty. I have also discussed that. The prohibition pertains to only enhancement of the punishment, not for reduction. That is decided in this AR 1983 Supreme Court, page 150. The Supreme Court categorically held that reduction of the punishment is not within the mischief of this prohibition contained in Part 2 of Article 20, Clause 1 of. So, with this we will end Article 20 Clause 1 ex post facto law. Now, we will go to Article 20 Clause 2, which deals with the double jeopardy, second one. Now, this double jeopardy, you know that also deals with this principle of artifice acquit and artifice convict. Now the other relevant provisions along with Article 20 Clause 2. Because before we deal with Article 20 Clause 2, let us just read what is Article 20 Clause 2. No person shall be prosecuted and punished for the same offence more than once. That is Article 20 Clause 2, which relates to this doctrine of double jeopardy. Along with Article 20 Clause 2, the other relevant provisions to be looked into on this doctrine is Section 300 CRPC, which deals with authorized acquit and authorized convict, and also Section 26 of General Clauses Act. 20 Clause 2, 26 of General Clauses Act, and Section 300 CRPC are the three relevant provisions dealing with, which are dealing with this subject. Now, Section 26 of General Clauses Act says that where an act or omission constitutes an offence under two or more enactments, when the offender shall be, then the offender shall be liable to be prosecuted and punished under either or any of these enactments, but not liable to be punished twice for the same offence. This is one. This is interesting now to be discussed. Now, suppose a person has committed one offence today, which he was prosecuted for that offence, and he was also punished. Then, again, if he is prosecuted for the same offence, then this principle of double jeopardy applies. Authorized acquit or convict will apply under Section 300 CRPC. Now, there is no difficulty then in such a case. But when a single act committed by a person constitutes offence under two different enactments, the same act constitutes an offence under two different enactments, then what is the position? Whether his prosecution is hit by this double jeopardy principle under Article 20 Clause 2 or not is the question. Now, Section 26 of General Clauses Act, that's what says that when an act or omission constitute an offence under two or more enactments, then the offender shall be liable to be prosecuted and punished under either or any of the laws, but shall not be punished twice for the same offence. That is the difference. See, it is in two parts. There will be confusion if you read this provision. First part says that when the same act constitutes offence under two different enactments, then he is liable to be punished under either of the enactments or any one of the enactments. Now, second part says that for the same offence he cannot be punished twice. So, for the same offence there is no difficulty, he cannot be punished twice. But the same act, when it constitutes two different offences, two different enactments, then what is the position is this. Here the law is that when the act constitutes an offence of two different enactments, when there are two distinct and separate offences, then this principle of authorized or double jeopardy will not come in the way. It will not be hit by the principle of jeopardy. For that, I can give you an example, classic example. You take an offence under Section 171G of IPC. Now, Chapter 9A of IPC deals with offences relating to elections. Okay. Now, Section 171A to 171G, 171I are the offences under this chapter 9A relating to offences. Now, let us see 171G. 171G. It says that false statement in connection with an offence means whoever with intent to affect the result of an election makes or publishes any statement purporting to be a statement of fact which is false and which he either knows or believes to be false or does not believe to be true in relation to the personal character and conduct of any candidate shall be punished with fine. This is the, ante during the process of election, because this is an electoral offence, chapter 9 here deals with electoral offences. 171G is one of the offences in that chapter. Now this 171G says, suppose there is election going on here. Take for example, a parliament election is going on here. Now one person made a statement or false statement touching the character or conduct of the candidate who is contesting the election, defaming him, touching the character and conduct. Suppose he has released a pamphlet, open pamphlet, saying that he is a man of bad character, his conduct is good, making some scandalous allegations against him. A pamphlet is there, knowing it to be false, a statement. Then it was made an offence under section 171G of the Act. Here, now, the same Act, 171G, this is an offence. Making a false statement touching the character and conduct of a candidate contesting election is made an offence under 171G. Now, the same Act is also an offence under 500 of IPC, defamation. If a person makes an imputation with an intention to defame, whether verbally or orally, మీరు 419 defamation తీసుకుంటే definition, any person makes any imputation verbally or orally with an intention to defame a particular person is said to have committed the offence of defamation, liable for punishment under 500 IPC. So there also he made a statement touching the character and conduct of a person, defaming him. That is an offence under 500 of IPC. Here also, but here also he made a same act of making an allegation of against a character and conduct of a candidate. It is made an offence under 171G for the simple reason that it was made during the course of the election. ఇక్కడ ఏమండి, ఇక్కడ ఇంగ్రీడియంట్ ఏమిటి ఇక్కడ, when whoever with intent to affect the result of the election. ఇక్కడ ఇంటెన్షన్ ఏమిటి, in making scandalous allegation touching his character to affect the result of the election. అక్కడ ఇంటెన్షన్ ఏమిటి, making same statement with intention to defame him. So act is the same, only intention varies. So here this is the classic example for separate and distinct offences. Same act constitute two different offences, separate and distinct offences. What intention makes the difference? Here the intention under 171G is to affect the result of the election. There the intention under 499 IPC mere definition chuskunte, intention is to defame him. Act is the same, but two different and separate offences. Here the principle of double jeopardy will not apply. Here, because why it is said that here that act of making a false statement against the character is made with an intention to affect the result of the election. Here the act of making a false statement touching his character is made to defame him. See, so there is the difference. So two separate and distinct offences. A classic example for this two separate and distinct offences. So the courts held that he can be prosecuted. Suppose now one candidate is contesting the election. Some X made the statement to affect the result of the election. Now the candidate who was affected by that act can prosecute the X both under section 175G and also 491 of IPC. Proof is different, leave it. But the prosecution is not hit by the principle of double jeopardy here. So this is the distinction you have to note while applying the principle of double jeopardy. That I will give you the judgment also on this 171G later. Now, Otherwise acquittal or otherwise convict will come. Very practical problem because my judicial officers are also here. We have to discuss here. Now you have an NI Act case 138. It is a trial by a magistrate, either by a summons procedure or by a summary procedure. Now, the complaint was absent. When the complaint was posted for trial, the complaint was absent. Now, the officers, after giving 2 more adjournments, since he is not turning up, they are dismissing the complaint. Okay? Dismiss చేస్తున్నారా? Okay, will come. Or 256, clause 1, acquitting him. I want to remove one doubt to the officers and the. See, dismissal of complaint at that stage is ex facie erroneous. Many, because we are seeing in the High Court and also we are seeing on the revisions and all, many officers are passing an order of dismissal at that stage. That's wrong order. Dismissal is not contemplated there. Owing to the absence of the complaint at the time of trial, the appropriate order be passed under 256 clause 1 CRPC is acquittal, not dismissal. So don't pass an order of dismissal. If you are inclined to exercise your power under 256 clause 1, pass an order of acquittal, but don't use the word dismissal. It is a fundamental error, I say, because in criminal proceedings, there is no procedure prescribed under CRPC, in the scheme of CRPC, of dismissing the complaint for default. Once the trial starts, dismissal is contemplated only at the pre-trial stage of the case. Suppose in a private complaint you conduct an inquiry under 200 CRPC and 202. If you find prima facie case to try the accused, you will take cognizance of the case and you will issue process. If you don't find prima facie case to take cognizance of the case, you can dismiss the complaint under section 203 CRPC. Their dismissal is contemplated, 203. Similarly, if you find prima facie meeku ledu, you decline to take cognizance, therefore you can dismiss on 203. Now you have found that there is a prima facie case to try the accused. Then you have taken cognizance of the case. You have issued process, summons to the accused. Now the complainant did not pay the process fee. Then you can dismiss again the complaint under 204 clause 4 CRPC. These are the only 2 stages where dismissal is contemplated at the pre-trial stage. Once you have taken cognizance and process is issued, process fee is paid, and accused made his appearance, then you will follow the procedure in 251 or something, then you will post the matter for trial. Remember that once you have taken cognizance and the matter has reached to the trial stage, post-trial stage, there is no question of passing this order of dismissal. That stage is over now, completed. Once the trial commences, there are only 2 possible orders that are to be passed. In warrants case, you got a step for discharge. Discharge chestaru lepothe trial ki veltaru. Then once you commence the trial, inka discharge, no dismissal. There are only 2 orders: acquittal, conviction. That's all. That is the fundamental principle you have to bear in mind. Now, in NI Act, you have taken cognizance, you have issued process, accused made his appearance. Now trial commenced. You have posted the case for examination of P.W. 1, the complainant. He did not turn up. You are given 2 adjournments. Still he did not turn up, he is absent. Then you are dismissing the complaint. Don't do that, because 256 clause 1 CRPC contemplates only acquittal for non-appearance of the complainant, not dismissal. So you can pass an order of acquittal there. Now, question is, 256 clause 1 kanda, you have acquitted the accused owing to the options of the accused. Options of the complainant. Now the complainant has filed a second complaint. Whether it is hit by double jeopardy or not. Now when second complaint is filed, the defense was taken by the accused saying that already complaint was filed against me. Already complaint was filed against me. And I was acquitted in that case under 256 clause 1 CRPC. Therefore, I am not liable for, again, prosecution punishment. Now, complainant says that, no, that was only dismissed for owing to my absence. There was no trial. He was not acquitted after full-fledged trial. Evidence was not recorded. There were no arguments. It was not on merits. There was no acquittal on merits. Now whether the second complaint is hit by the double jeopardy under Article 20 Clause 2 or under Section 300 CRPC. Anybody? Hit by? Why?
And he can't be again convicted on a.
What do you say about the contents of the complaint?
Suppose if the complaint is dismissed in the NI Act, he can file a petition to restore the complaint because it is a quasi-civil. So he can file to restore the petition. Once he was acquitted, again he can't be convicted in the second complaint.
What do you say about the contents of the complaint? That
even though the contention may be
there was no trial,
that trial was not
there was
conducted,
no trial,
and arguments were not heard, all these things are not arise.
No evidence was recorded.
Do not arise.
My guilt is, his guilt is not decided, or his innocence are not decided on the basis of the evidence or merits.
Even then, he was acquitted once. He can't be convicted again. That is my submission.
Good. Your answer is correct. Your answer is correct, because once there is an order of acquittal under 250, because 256 clause 1 contemplates acquittal. Now the magistrate has exercised his power under section 256 clause 1 CRPC and has acquitted him. And for a better understanding, let us read 256. Uh, 256 of CRPC, non-appearance or death of complainant. It is in two parts. One deals with non-appearance, two deals with death of the complainant. If the summons has been issued on complainant and on the day appointed for the appearance of the accused, or on any day subsequent thereto to which hearing may be adjourned, the complaint does not appear, the magistrate shall, notwithstanding anything hereinafter before contained, acquit the accused. Acquit the accused unless for some reasons he thinks fit proper to adjourn the hearing of this. So, whether it is on full trial or on account of the absence of the complainant, the proper step that is to be proper order that is to be passed under 251 is acquittal. So once there is an order of acquittal, then the principle of atrefas acquit comes into operation. So the second complaint is barred. Second complaint is not maintainable. Here, there is a judgment of our Espal High Court of AP, Justice Punaigar judgment undi, elaborately discussed on this issue. If the reference to earlier judgments of the Madras High Court and all, very good judgment. All of you, the youngsters, have to read this. This is in U. Muniswami Naidu versus Pullama Naidu. I think I have picked up in Manapatra. You can go to by citation అంటే కరెక్ట్గా లేదు ఇక్కడ. It was an 82 judgment, 82 years. Para 11, in your the majority view in Dudekula Lal Sahib case, the legal position regarding the order of acquittal passed under 256 is that the acquittal of the accused under section 256 CRPC operates as bar under section 300 clause 1 CRPC against the second complaint against the same accused for the same offence, and the acquittal order under 256 CRPC does not fall within the explanation to section 300 CRPC. Okay? A direct judgment on this second. Emma? Parties. U. Muniswamy Naidu versus S. Pullama Naidu. 1982 to Justice Subbareddy garu is assisting me. 82 to ALT 300, page 300.
Lordship, kind permission, little clarification.
చెప్పండి.
Because the doctrine of double jeopardy, the article subclause 2 of article 20 itself clearly mentions a person cannot be not only convicted twice, but he cannot be tried twice also for the same offense.
That's what.
So that itself contemplates, Your Honor, though the complaint was dismissed for non-appearance of the complaint, again basing on the second complaint, he cannot be tried.
అక్కడే కింద అందుకే మీకు స్టార్టింగ్లోనే నేను ఐ స్టార్టెడ్ విత్ డిస్మిస్ల్ అనేది లేదు. దట్స్ రాంగ్. దట్స్ వాట్ ఆఫీసర్స్ ఆర్ డూయింగ్ రాంగ్. ఐ థింక్
దట్ ఈస్ ది రీజన్.
ఆ డిస్మిస్సల్ రాకూడదు. అయితే ఇక్కడ ఫర్ టు క్లారిఫై యువర్ డౌట్,
once
one minute.
He was acquitted, he is doomed to be acquitted after trial.
అంటే
Whether it is on merit or
see, irrespective of the fact whether the acquittal was after full trial or on account of his absence,
non-appearance of the
it is immaterial. He is entitled for acquittal, and that is acquittal is for operates as a bar for second trial.
Yes, sir.
There is a settled law in this.
Yes, sir.
మా డిస్మిస్లు అంటున్నారు కదా, ఇప్పుడు వస్తున్నాను దానికే వస్తున్నాను. అందుకే ఫర్ ఎగ్జాంపుల్ ఇందాక మనం డిస్కస్ చేశాము, కాగ్నిజెన్స్ తీసుకోలేదు, ఇంకా ప్రైవేట్ కంప్లైంట్ వేశారు, 202 ఎంక్వైరీ అయ్యింది, మ్యాజిస్ట్రేట్ ఫౌండ్ మ్యాజిస్ట్రేట్ ఫౌండ్ దేర్ ఇస్ నో ప్రైమా ఫేసి కేస్ against the accused to take to cognizance against him and to try him. Therefore, magistrate has dismissed the complaint 203. ఇక్కడ 203 ఒకసారి చెప్తాను. Dismissal of complaint. ఇదేం చెప్తుంది? If after considering the statements on oath of the complainant and of the witnesses and the result of the inquiry or investigation under section 202, the magistrate is of opinion that there is no sufficient ground for proceeding, he shall dismiss the complaint, and in every such case he shall briefly record the reasons for so doing. ఇక్కడ magistrate did not find prima facie case to take cognizance. Magistrate dismissed the complaint and 203 CRPC. ఇప్పుడు డిస్మిస్ చేసిన తర్వాత సెకండ్ కంప్లైంట్ వేశారు.
not maintained.
ఎందుకు మెయింటైనబుల్ కాదు?
Because the earlier order that was passed by the magistrate is an appealable order.
ఇక్కడ ఎక్విటల్ లేదు, డిస్మిస్లే ఉంది.
Yes, sir. Though it was dismissed, Your Honor, it is an appealable order. The option for the complaint is to appeal, prefer an appeal. Though the second complaint basing on the same facts is not applicable.
Good. Here I disagree with you. Go to section 300 CRPC, which deals with the atrophies acquittal and atrophies conviction. Now, 300 ఏం చెప్తుంది? ప్రయర్ ఎక్విటల్ ఉన్నా ప్రయర్ కన్విక్షన్ ఉన్నా సెకండ్ ప్రాసిక్యూషన్ ఇస్ బార్ చెప్పింది. ఇప్పుడు ఎవ్రీబడి విల్ మిస్ దిస్ సెక్షన్ 300 ఎక్స్ప్లెనేషన్ చదవండి, లాస్ట్లో ఉన్న ఎక్స్ప్లెనేషన్. The dismissal of a complaint or the discharge of the accused is not an acquittal for the purpose of this section. So 202 కింద 203 కింద అక్కడ డిస్మిస్ చేస్తే there was no order of acquittal, there was only an order of dismissal. Now in order to attract the provisions of 300 CRPC authorized acquittal, there must be an order of acquittal, order of conviction. Here dismissal explanation ఇచ్చి ఏం చెప్పారంటే the dismissal of a complaint or the discharge of the accused is not an acquittal for the purpose of this section. Therefore there is no bar for second complaint. It is not hit by the principle of authorized acquittal or conviction or the principle of double G of Pade, because cognizance తీసుకోలేదు అతని మీద. He was not summoned, he was not tried, he was not convicted or he was not acquitted. That is the principle there. Now అందుకే డిశ్చార్జ్ కూడా ఈవెన్ కాగ్నిజెన్స్ తీసుకున్న తర్వాత కూడా సపోజ్ పోలీస్ కేసు ఉంది, ఛార్జ్ షీట్ వేశారు వాళ్ళు, కోర్ట్ హ్యాస్ టేకెన్ కాగ్నిజెన్స్, at the time of framing charges you are discharged, some ground evidence lack of discharge చేసింది కోర్టు. Even then also the second complaint is not barred, because dismissal or discharge is not an acquittal for the purpose of 300 CRPC is the statutory requirement here in this case. That is the main principle. That is why I think recently there's one my judge it was reported also on 319 CRPC, where I have dealt all this elaborately this law. The Supreme Court said even in under 319 of CRPC ట్రయల్ అయిపోయి లాస్ట్ ఫ్యాగ్ ఎండ్కి వచ్చేటప్పుడు ఒక విట్నెస్ వచ్చి చెప్తాడు, పలానా వాడు కూడా కమిట్ చేశాడు అక్యూజ్ అని చెప్పి ఉన్నాడు ఇందులో వీళ్ళతో పాటు అని. దెన్ ప్రాసిక్యూషన్ ఫైన్స్ పిటిషన్ 319 కదా, వాడిని కూడా ఇప్పుడు యాడ్ చేయండి అని చెప్పేసి వాడు వస్తాడు, నేను ఎప్పుడో డిశ్చార్జ్ అయిపోయాను ఆల్రెడీ, కోర్టే డిశ్చార్జ్ చేసింది నన్ను, మళ్ళీ నన్ను ఇప్పుడు సమన్ చేస్తారు అలాగని చెప్పేసి. సుప్రీంకోర్టు సెడ్ నో నో నో, ఈవెన్ ఇఫ్ యూ ఆర్ డిశ్చార్జ్డ్, కోర్టు ట్రయల్లో ఎవిడెన్స్లో వాడు వచ్చి నీ పాత్ర కూడా ఉందని విట్నెస్ చెప్తే పిలవలసిందే, వాడు ట్రయల్ ఫేస్ చేయవలసిందని చెప్పేసి హెల్డ్. నాట్ ఓన్లీ దట్, అనదర్ ఇంట్రెస్టింగ్ కేస్ దట్ వీ హ్యావ్ రిఫర్డ్ ఇన్ దట్ కేస్. Suppose FIR was quashed against him. There are 5 accused. One accused filed 482 quash. High Court has quashed the FIR against him. Other 4 accused faced the trial. ట్రయల్కి వచ్చేసరికి ఎవిడెన్స్లోని విట్నెస్ ఏం చెప్పాడు, ఆ 5th accused కూడా ఉన్నాడండి, he has committed offense along with these 4 అని ఎవిడెన్స్ చెప్పారు ఇద్దరు. దెన్ పీపీ ఫైల్ అప్లికేషన్ 319 యాడ్ చేయండి వాడిని అని చెప్పేసి. దెన్ హీ హాస్ టేకెన్ అబ్జెక్షన్, నా మీద ఎప్పుడో హైకోర్టు ప్యాస్ చేసింది నా మీద కేసు అన్నాడు. నో, సుప్రీంకోర్టు సెడ్ ఈవెన్ దెన్ యూ మస్ట్ బి ఇంప్లీడ్ అండర్ 319, యూ మస్ట్ బి ట్రైడ్. సో దట్ ఈస్ ది లా. సో అల్టిమేట్లీ ది ప్రిన్సిపల్ ఈజ్ there must be a clear order of acquittal or a clear order of conviction for the purpose of applying the principle of double jeopardy to bar the subsequent prosecution and conviction or acquittal. If there is no order of acquittal or conviction and only dismissal, discharge were there earlier, they are not hit by the principle of the double jeopardy. Second complaint is maintainable. Now, so with this doubts are clarified or any doubts are there on this double jeopardy? Now, when the second complaint is maintainable, recently Supreme Court had an occasion to deal with. In 2022 live law SC 1022, very recent judgment, here the Supreme Court clearly held that when a second complaint is maintainable and when that principle of double jeopardy cannot be applicable are all dealt with in this judgment. You can see this. Some of the instances they have given. So these are the 2 judgments on this aspect. 2022 live law SC 1022 పార్టీల పేర్లు కావలిస్తే బీఆర్కే స్పెల్లింగ్ రాసుకోండి, AATHITHAN వర్సెస్ సన్ గ్రూప్ అండ్ అనదర్ ఇందులో ఎర్లియర్ జడ్జిమెంట్స్ కూడా 62 సుప్రీంకోర్టు ఇవన్నీ కూడా రిఫర్ చేశారు 2012 1C అండ్ దే హెల్డ్ అండర్ సర్టన్ సర్కమ్స్టాన్సెస్ ది సెకండ్ కంప్లైంట్ ఈస్ మెయింటైనబుల్ ఆన్ దిస్. On this two separate and distinct offences is concerned, we have some more interesting cases you can note down. In one case, in Makul Hussain versus State of Bombay, AR 1953 Supreme Court 325. In that case, what was happened is that a person on arrival at the airport did not declare that he brought gold with him. But on search it was found that he was carrying 107 tulas of gold in contravention of the government notification. Now the customs authorities thereupon took action against him under section 167(8) of the Customs Act and confiscated the gold. So he brought the gold, he did not declare that he has brought the gold, but the customs authorities found that he was in unauthorized possession of the gold. So they have initiated proceedings against him under Sea Customs Act and confiscated that gold. Now, again, sometime thereafter, a complaint was filed against him under section 8 of Foreign Exchange Regulation Act. Foreign Exchange Regulation Act to prosecute him before the magistrate for violation of those provisions, foreign exchange provisions. Now, he has taken a plea in this prosecution before the magistrate under Foreign Exchange Regulation Act that Article 20 Clause 2 applies WO per day because I was already dealt with under the Customs Act, my gold was confiscated. Now again they are prosecuting me under this Foreign Exchange Regulation Act for the same act. Then the court held that same act, two different and separate offences are constituted. One is for not declaring that you brought gold unauthorizedly before the customs. Another is for being in possession of the gold contrary to the provisions of Foreign Exchange Regulation Act. So it is not hit by the WO per day. The same act constitutes two different and separate offences under two different separate enactments. Therefore, you are liable. Confiscation does not amount to prosecution also, it was held in this state. That was only a confiscation. This is for prosecution for which is an offence under this act. So this is also another interesting case on this double jeopardy. Now, the other principles are many of you all know about this. When the same act gives rise to committed by an employee, gives rise to an action under departmental proceedings and also the criminal prosecution, it will not be hit by the principle of this WO per day. That is settled law. But if you want a judgment on that, you can note down this S.A. Venkatraman versus Union of India, AR 1954 Supreme Court 375. And recently when we are dealing with that offence under 171G of IPC and also 500 IPC, we said that the same act constitutes offence under 171G and 419 of IPC. The only difference is intention. Their intention is to affect the result of the election. Here the intention is to defame him. So why the same act is liable for prosecution two enactments? That was explained by the Supreme Court. In order to attract the principle of double jeopardy under Article 20 Clause 2, the ingredients of both the offence also must be the same. That is the test. So there one of the ingredients differ, main ingredient differ, where the intention differ there. So so the Supreme Court said here, the same offence would mean an offense whose ingredients are the same, that is decided in State of Bombay versus S.L. Apte, AR 1961 Supreme Court, page 578. So, if the same act constitutes two different separate offences, when the ingredients of the offence are also not the same and they differ, then this principle of double jeopardy is not applicable. Same is the case. In one case, the accused was sought to be prosecuted under Section 105 Insurance Act for misappropriation of some amount relating to that insurance policy. At the same time, he was also prosecuted for the offence under 409 of IPC. Again, the same defence was taken. I was already prosecuted under 105 of Insurance Act for the same offence. Again, my prosecution for 409 is not maintainable. Then the Supreme Court answered like this. The second prosecution must be for the same offence. If the offence is distinct and separate, there is no question of the rule as to double jeopardy being applicable. Thus, where the accused are sought to be punished for the offence under Section 105 Insurance Act after trial and conviction, for the offence under Section 409 of IPC, they are not being sought to be punished for the same offence. So, this was also decided in the case of Leroy Frey versus Superintendent of District Jail, AR 1958 Supreme Court 119. So, this is the law relating to the double jeopardy under Article 20, Clause 2 of Constitution. So, anyone doubt on this, you can clarify, or we will go to next 20, Clause 3. No doubt. Yes?
Now the separate courts are constituted to try the offences under Section Prevention of Scheduled Caste Atrocities and Scheduled Caste Act, which is called as SC/ST court. Now the separate courts are constituted to try the offences under Section Folks Act. Here there is a little confusion. Which court has to be tried those offences?
See, when there are two distinct and separate offences with the same act, then the principle of this double jeopardy will not come in the way.
I am not insisting for applying the double jeopardy.
Then?
Now the police are filing charge sheets in several cases where the victim is a minor, that too she belongs to a tribe SC/ST community. Though under those sections of those provisions under the SC/ST Act and the Folks Act also, they are incorporating the sections in the charge sheet. Now the courts are very confusing to which court that case has to be made and to be tried in which court, whether in the Folks court or in the SC/ST court. The victim is a minor, she belongs to scheduled community.
Mr. Chidambaram wants to answer that. I can answer.
When there is a special enactment under SC/ST Act, Folks court has no jurisdiction to try the offences where the victim is SC/ST community people.
Answer చేశారు అది is not satisfied with that, your answer? Okay, we will 1 minute. let me finish this third principle, then we will discuss.
Yes, sir. Yes, Lord.
Okay, friends, now the third principle under Article 20, Clause 3 is that the testimonial compulsion or a principle of self-incrimination. 20 Clause 3 reads like this. No person accused of any offence shall be compelled to be a witness against himself. That is which is called as principle of testimonial compulsion or self-incrimination. Now, see, for example, 161 CRPC is there, where statements of witnesses will be recorded by the investigation officer during the course of investigation. Now, the section says, 161 says that any person, statement of any person can be recorded, any person who is acquainted with the facts of the case can be examined by the investigation officer and he can record. Now, whether an accused can be examined under 160. Take for example, a crime is registered, it is being investigated. Now, the crime was registered against 4 persons, A1 to A4, and one suspect accused was also there, fifth person. Now, the IO has given, summoned the accused person and also a suspect accused for examination under 161 CRPC. Now, that was challenged before the court. See, when I am the accused, how can the IO summon me to record my statement? It amounts to testimonial compulsion and self-incrimination. So, whether the police officer can examine an accused under 161 CRPC or a suspect accused. And another contention raised by the accused is that the word used there is a person. Prosecution used contention. Word used is there is a person. So, when a word person is used, wide enough to include even the accused. But the accused says that it amounts to testimonial compulsion, examining me and recording my statement. So, whether the summoning of that accused person or recording his statement 161 CRPC would be hit by this principle of self-incrimination or testimonial compulsion. Anyone can answer?
To my knowledge, there is no prohibition to summon him for the purpose of investigation. But when the statement of an accused was recorded during the course of investigation, he cannot be compelled as a witness against him within the provisions of Clause 3 of Article 20. That is to my knowledge.
Okay, now to save time, I'll give 2-3 instances and we'll answer one at the same time. Now, that is one aspect. Okay. Now, the same during the course of investigation, police have given a requisition to the accused to give his thumb impressions, footprints, and etc. And that was also challenged by the accused in the court, saying that insisting me to give my thumb impressions or my footprints when I am an accused amounts to testimonial compulsion or self-incrimination. So, whether police can insist the accused and whether it is hit by the principle of this self-incrimination and testimonial compulsion. Second issue. Then 160 CRPC, police summons an accused person. 160 says that police can summon any person who is acquainted with the facts of the case for the purpose of examining him in connection with the investigation. 160 CRPC. So, a police summons accused person under 160 CRPC. Now, that is also challenged. When I am an accused, how can police summon me for the purpose of investigation? That amounts to testimonial compulsion. This is another. So these are all the instances which usually come, we will be confronted with in connection with this principle of the testimonial compulsion or self-incrimination. And lastly, another one. Police issues notice under 91 CRPC to the accused person to summon a document, to produce a document before them for the purpose of investigation. Now, there also 160 also the word person is used. So the accused say, whether police says that person includes accused, but accused says summoning a document from me when I am an accused amounts to testimonial compulsion. So whether it is valid or not. So 4 instances. Who is that? During the search. That was again challenged. Searching my house when I am an accused in the case and collecting incriminating material amounts to testimonial compulsion. So these are all the practical issues usually will be confronted with in connection with the testimonial compulsion.
So far as the 4 questions are concerned, so far as first question is concerned, whether the police can record the statement of the accused. The police have absolutely no right to record the statement of the accused. It will amount to the confession made by the accused to the police officer, which is hit by under section 25 of Evidence Act. So far as next question is concerned, whether police can take the LT thumb impressions and footprints. The police have got right to take the thumb impressions and footprints during the part of the investigation. So far as theft is committed, the thumb impressions are very important on the doors and on the lockers. So
Okay, important, okay. But what about that plea taken by him, that testimonial compulsion?
the police can seize the thumb impressions from the articles, that is gold articles or the cupboards and then obtain the thumb impressions in open court and send to the expert.
We will conclude because 2 more judges still have to address you. We will conclude. Come on. No.
Yes, sir.
Conclude, yes. No. It's covered by my judgment itself. I discussed everything in that. Come on, I'll discuss. See, from 1952 onwards till recently, all these aspects have been dealt with both by the Supreme Court and various high courts, including our High Court. First, I will cover that search and seizure, search of an house of the accused, and collecting incriminating material during the course of investigation. That is held to be not hit by the principle of testimonial compulsion. In MP Sharma case 1952, 5 judges bench, first case. Okay. Then summoning or examining the witness and accused 161 CRP or summoning him, accused or a suspect accused also. That was answered by a 3-judge bench of the Apex Court by Justice Krishna Iyer. In Nandini Satpathi's case. 1978 2 SCC, page 424. In this case, in Nandini Satpathi's case, a former Chief Minister of Orissa, she was prosecuted under the provisions of Anti-Corruption Act. She was one of the accused, earlier also suspect accused. Investigation officer summoned her under section 161 CRPC to examine her and record her statement. She challenged the same in the Apex Court. When I am an accused or a suspect accused, how can I be come under 161 CRPC and be examined on 161 CRPC? Supreme Court has for one of the points formulated by the apex court in that is because 161 ఏమందంటే any person అని word use చేశారు. So the interpretation of this term any person was made by Supreme Court there. Supreme Court does any framed a point that does any person in section 161 CRPC include an accused person or only a witness? Answering the point, the 3 judges bench of the apex court held that the word person used in 161 CRPC includes an accused person. So there is no bar. It does not amount to testimonial compulsion. Now, similar word is used any person 160 CRPC. There also, the courts held that while interpreting this term person, any person used in 160 CRPC includes accused. Accused also can be summoned under section 160 CRPC for examination. Your police officer is wrestling very interestingly because it is in his favor. Now we will summon accused persons under 160. Okay. So the settled law is that any person used in 160 CRPC to summon a person for examination during the course of investigation and any person used in 161 CRPC includes an accused person, there is no bar for it. That is the interpretation given to it. Now interestingly, the same word person is used in 91 CRPC also. Police officer can summon any person to produce a document. Now, see, any person is used 160, 161. అక్కడ అక్యూజ్ని కూడా పిలిచి ఎగ్జామిన్ చేయొచ్చు అనేసి 161 కింద అని చెప్పి అన్నారు. 161లో అక్యూజ్ని కూడా పిలవచ్చు ఇన్వెస్టిగేషన్కి అన్నారు. నౌ 91కి వచ్చేసరికి అక్కడ కూడా ఎనీ పర్సన్ క్యాన్ బి సమ్మన్ టు ప్రొడ్యూస్ అ డాక్యుమెంట్ అన్నారు. నౌ దిస్ 91 నోటీస్ వాజ్ ఛాలెంజ్ బిఫోర్ ది అపెక్స్ కోర్ట్. Summoning a document from me when I am an accused amounts to testimonial compulsion was considered there. Now what do you say? Whether an accused can be summoned to produce a document? Why? మరి అక్కడ 161 గా నిన్ను పిలిచి ఎగ్జామిన్ చేసి ఇవ్వచ్చు, నిన్ను విచారణ చేసి ఇవ్వచ్చు 161 కింద. Okay. So you are correct. 91 ఇక్కడికి వచ్చేసరికి while interpreting the word person used in 160 and 161 CRPC, courts have given a wider interpretation and included accused in it and held that the word person used in 160 and 161 includes accused also. It can be given under 160 and 162 accused. But here, while coming to 91, the same word, while interpreting the same word person, the Supreme Court has taken a view that, but has given a narrow interpretation to it. There they have given a wider interpretation. Here the Supreme Court has given a narrow interpretation, said that person does not include accused. So, accused cannot be summoned to produce a document for the court. That was decided by the apex court, 5 judges bench, constitutional bench, judgment in 1965. Just I will give you. AR 1965 Supreme Court 1251. State of Gujarat versus Shyamlal Mohanlal Choksi case here. Because recently I had an occasion to deal with this issue. And I have discussed entire law on this. This was also reported in Munapatra, Kadiyala Samachalam versus State of Andhra Pradesh, the judgment. It was already reported in last summary also. See, in before this, you note down one more judgment also of 11 judges bench of the Supreme Court that is dealing with this aspect of taking fingerprints, footprints and identification, etc. Supreme Court upheld that it is not hit by testimonial compulsion. That judgment was in 1961 Supreme Court, AR 1961 Supreme Court, 1808. A 11-judge bench of the apex court in Kartikalu Ogat case is a famous case, that one. So ultimately what the Supreme Court held is that, while stating that taking fingerprints, footprints is not hit by testimonial compulsion, is that it means because they have, how carefully they have gone through the Article C. What is stated in Article 20 Clause 3 is that no person accused of an offence shall be compelled. A compelled word has made the difference. Compelled to be a witness against himself. Suppose if a accused voluntarily comes forward and if he gives a statement even against himself, that is not hit by this Article 20 Clause 3, unless it is shown that he is compelled to give. So Supreme Court in the Kartikaudi case, 11 judges bench held that to attract this doctrine of testimonial compulsion, Article 20 Clause 3, it is not enough mere showing that the statement was obtained from the accused or evidence was obtained from the accused. Something more is required to attract this doctrine. What is that something more? That is, it must be shown that it was obtained by compulsion. Unless it is shown that it was obtained by compulsion, it is not hit by the principle of the testimonial compulsion. A word learned on testimonial compulsion. That's why the fingerprints study, police officer has given, give me your fingerprints or footprints. If he gives, nothing. If he says, no, I don't give. But if he forces him, that's why a compel word code interpret chesaru, jurors, under jurors. So it was obtained by compulsion or under jurors against his will. Then this principle of testimonial compulsion applies. But if it is voluntarily given, it will not be applicable. So taking that into consideration, the Supreme Court held in the Kartikalu case 11 judges bench, obtaining thumb impressions or footprints for the purpose of collecting evidence during the course of investigation does not amount to testimonial compulsion. It is not hit by that principle. Unless something more is shown that it was taken by compulsion, it is not hit by that. That is the main principle involved in this. So now, so far as this distinction between 60, 61, 60 and 161 and 91, అక్కడ పర్సన్ కేంచి వైడ్ ఇంటర్ప్రిటేషన్ ఇచ్చారు, ఇక్కడ నేరో ఇంటర్ప్రిటేషన్ ఇచ్చారు. అక్కడ ఎక్యూజ్ని ఎగ్జామిన్ చేయొచ్చు అన్నారు, సమన్ చేయొచ్చు అన్నారు, ఇక్కడ డాక్యుమెంట్ సమన్ చేయకూడదు అన్నారు. ఇక్కడ ఆ రీజన్ ఏమిటనేది మీకు 65 సుప్రీం కోర్ట్ చెప్పాను కదా, ఈ 5 జడ్జెస్ బెంచ్, దట్ వాజ్ డిసైడ్ ఇన్ దట్ కేస్, దట్ శ్యామ్లాల్స్ కేస్. If you go through that, you will know the reasoning. There only because if you go through my judgment in Kadiyala Simachalam case, at para 14, I have summed up like this. To sum up, in Nandini Satpathy, one of the points formulated by the apex court is, does any person in section apex court has given a restricted meaning and has put on a narrow construction on it and held that it does not include an accused person. So this is the law on this 161. But frankly to say, my personal opinion is that because it's a 5-judge bench, now we have to follow is a constitutional 91 CRPC kuda. When the courts have had held that accused నేను 161 CP పిలిచి నువ్వు ఎగ్జామిన్ చేయొచ్చు, స్టేట్మెంట్ రికార్డ్ చేయొచ్చు, 161 కన్నా సమన్ చేయొచ్చు, నువ్వు ఎగ్జామిన్ ఇంట్రాగేట్ చేయొచ్చు అన్నప్పుడు 91 కన్నా డాక్యుమెంట్ ఎందుకు సమన్ చేయకూడదు అన్నది సంవాట్ కొంచెం ఇన్కన్సిస్టెంట్గా ఉంది. రీజన్ దే హ్యావ్ గివెన్ హియర్, దే హ్యావ్ గివెన్ వైడర్ ఇంటర్ప్రిటేషన్ టు ది సేమ్ వర్డ్ పర్సన్ యూజ్ ఇన్ similar context, but there they have given a restricted interpretation and narrowed down its scope and restricted to only accused in witness in 91 CRPC. My humble view is that because it was the view taken in 1965, Shamlar's case, it requires reconsideration. But we can't do help. I can't say, because unless judges sitting in the Supreme Court, again, prosecution challenge is there, again it may be referred to larger bench. In view of these two judgments, Kartik Audu case of 11 judges bench and Nandini Satpathi's case in 1978, my view is that this 91 CRP requires reconsideration. So, so far as testimonial compulsion is concerned, these are the important judgments which requires for which are to be discussed in the present context. So ultimately, so far as 20 clause 3 testimonial compulsion is concerned, advocates should bear in mind, also judicial officers and police officers here, to apply that principle. The predominant requirement is that it must be shown that the statement was obtained by compulsion, by force, under duress. Then only that principle can be applied. If it is voluntarily made, it will not apply. That is the reason why Section 27, constitutional validity of Section 27 of Evidence Act is also upheld by the Apex Court. You all know Section 27, very handy provision for the police, because one of the Supreme Court judges, now retired, in one of the similar seminars said that I am yet to see a criminal case without the evidence of Section 27. ఏ కేసు కూడా పోలీస్ వాళ్ళు 27 రికవరీ లేకుండా, ఏ కేసు పెట్టరు ఆ ఎవిడెన్స్ లేకుండా, because that is so handy to them. That was upheld by the Supreme Court, because see what is stated, that police will record a confession statement and the trial courts will not admit that part of confession statement, that will be eliminated by Section 25. But 27 will take into consideration. Why? Accused says, voluntarily says, if you come with me, I will show where I have hidden that weapon or that incriminating material, and he will lead them. So he has voluntarily taken them. There is no compulsion there. Therefore, it is not hit by the testimonial compulsion of 20 clause 3. That is how it was upheld. See, అందుకే మీరు చూడండి, 25 says confession before the police not valid, పోయింది 26. 27కి వచ్చేసరికి, అందుకే ది ఓన్లీ సెక్షన్, మీరు ఏ యాక్ట్లో చూడండి, ఏ సెక్షన్ కూడా ప్రొవిజర్స్తో స్టార్ట్ అవ్వదు. మీదనే మెయిన్ సెక్షన్ నుండి నెక్స్ట్ ప్రొవిజర్తో స్టార్ట్ అవుతుంది. బట్ ది ఓన్లీ సెక్షన్ 27 ఇన్ ఇండియన్ ఎవిడెన్స్ యాక్ట్ ఇది స్టాండ్ అలోన్ సెక్షన్ విచ్ స్టార్ట్స్ విత్ ది ప్రొవిజో. ప్రొవైడెడ్ అనుకోని అది ఒక్క సెక్షన్ స్టార్ట్ అవుతుంది. దేనికి ప్రొవిజో? అది ప్రొవిజో ఈజ్ ఆల్వేస్ ఎన్ ఎక్సెప్షన్ టు ది మెయిన్ పార్ట్. So Section 27 is exception to Section 25 and 26. That's how we have to read. Why it is made valid? Because there is no compulsion to admit that evidence under 27. Voluntaryగా తీసుకెళ్తాడు కాబట్టి అది. So the ultimate test is, it must be shown that there is a compulsion in obtaining the statement or evidence to attract the bar under 20 clause 3. So with this, I thank you all for the patience, hearing and
Thank you, sir. Now we can claim that we are constitutional lawyers, because we know at least one of the provision of the Constitution thoroughly. In fact, my lord was not well. When 1.5 hours was allotted, Justice Manavendra Rai garu told me that I may not take that much time because he was not well. But now my lord has crossed 1.5 hours. Now,
that's my weakness. Once I start discussing the subject, even nothing prevents me.
now Justice Jayasuri garu, standards of the legal profession. Justice Jayasuri garu and Justice Subbareddy garu. It is the launching ground for both of the learned judges. The first time they are going to take seriously delivering of the lectures on a specified subject. Thank you, sir.
Sir, it's not a lecture as such.
లెక్చర్ అంటే ఇప్పటికే వాళ్ళు లంచ్ టైం అయిపోయింది, ఈయన లెక్చర్ మొదలు పెట్టాడు, ఇది ఎప్పుడు అవుతుందో అనుకుంటారు. సో డోంట్ వరీ, ఇట్స్ నాట్ ఎ లెక్చర్. ఐ జస్ట్ వాంట్ టు షేర్ మై వ్యూస్ ఆన్ ది టాపిక్ అలాటెడ్ టు మీ, that is standards of legal profession. But before that, President of today's seminar, Mr. Ganta Ramarao, Chairman Bar Council of AP, Chief Guest of today's seminar, Justice Seshai Garu, Judge High Court of Andhra Pradesh, Justice Manavendra Roy Garu, Judge High Court of Andhra Pradesh and Portfolio Judge of West Godavari District, Mr. Subbareddy, sorry, because I am very close to Mr. Subbareddy, Justice Subbareddy, Judge High Court of Andhra Pradesh, Mr. Purushottam Kumar, Principal District Judge, West Godavari District, Mr. Chidambaram, Member Bar Council of State of Andhra Pradesh, Mr. Krishna Reddy, Member Bar Council of State of Andhra Pradesh, the other dignitaries on the dais, that is Mr. Sachinarayana, President of Narsapuram Bar Association, Mr. Subbarao, President of Palakallu Bar Association, Mr. Chandrasekhar Reddy, Member Bar Council of State of Andhra Pradesh, Madam Madhavi, Member Bar Council of State of Andhra Pradesh, Secretary of Bar Council of State of Andhra Pradesh, their staff, Mr. GVK Ramarao, Leonard Senior Counsel, Senior Advocate, other advocate friends, young members of the bar, judicial officers, ladies and gentlemen. Good afternoon to one and all. చిదంబరం గారు ఈ సెమినార్ ఆర్గనైజ్ చేసే ముందు మీరు కూడా వచ్చేదో టాపిక్ ఒకటి మీరు మాట్లాడవలసి ఉంటుంది. యూ హ్యావ్ టు అడ్రస్ యంగ్ మెంబర్స్ ఆఫ్ ది బార్ ఆన్ స్టాండర్డ్స్ ఆఫ్ లీగల్ ప్రొఫెషన్ అనేసి అన్నారు. బట్ ఇక్కడ చూస్తే నాలాగా ప్రసాద్ గారి లాగా చాలామంది బాల్ హెడ్స్ కనబడుతున్నారు. ఐ డోంట్ నో హౌ మెనీ ఆఫ్ ది యంగ్స్టర్స్, young advocates who are having less than 3 years of standing at the bar. ఎంతమంది 3 ఏళ్ళ కంటే తక్కువ స్టాండింగ్ ఉంది బార్లో? ప్లీజ్ రేజ్ దేర్ హ్యాండ్స్. చాలా తక్కువ మంది ఉన్నారు. బికాస్ ది టాపిక్ ఈజ్ ఇంటెండెడ్ ఫర్ ది యంగ్ మెంబర్స్ ఆఫ్ ది బార్ who are required to maintain standards of legal profession. So what are the standards of legal profession? Can anybody tell? Or I'll ask one more question. Why this legal profession is called a noble profession? Can anybody answer? Well, because it is upholder of law and protector of law. That's why it's called a noble profession. The Honorable Supreme Court had an occasion to deal with the rules framed by Bar Council of India, and in a judgment rendered in Indian Council of Legal Aid and Advice and Others versus Bar Council of India, observed that the practice of law is pious and honorable profession, with its primary goal being the service of humanity by supporting the administration of justice. So when it is pious, the practitioners of law are required to maintain certain standards. They have to follow certain ethics, certain principles. And what are all these, say, principles, standards, whether they are codified anywhere? Can anybody say that whether the standards of legal profession are codified anywhere? Not codified. Well, but Bar Council of India had framed certain rules. Of course, in my personal view, they are not covering the entire field. They are covering certain field, how to conduct yourself being an advocate in the legal profession. But the Honorable Supreme Court, in the very same same judgment in Indian Council of Legal Aid and Advice, had also observed, and I'll read the relevant portion from the judgment. Since the duty of a lawyer is to assist the court in the administration of justice, the practice of law has a public utility flavor, and therefore he must strictly and scrupulously abide by the code of conduct behoving the noble profession, and must not indulge in any activity which may tend to lower the image of profession in society. So, in order to maintain a dignity, image of a legal professional, you have to follow certain standards, though they are not specifically mentioned anywhere, to my knowledge, by the Bar Council. However, the Bar Council, exercising its powers under Section 49, have framed certain rules. I'll take you, or I'll mention a few rules which are relevant for the practitioners. 49 provides for, Section 49 of Advocates Act provides for general power of Bar Council of India to make rules, and 49(1)(c) provides for standard of professional conduct, etiquette to be observed by advocates. So, exercising that power, the Bar Council had framed certain rules. Of course, most of the seniors are well aware of those rules. For the benefit of the youngsters who are present here, I would like to mention few rules. And before that, the preamble of the rule says, an advocate shall fearlessly uphold the interests of his client, and his conduct conform to the rules hereinafter mentioned in true letter and spirit. The rules hereafter mentioned contains canons of conduct, etiquette, adopted as general guides. They are also mentioning it is general guides. Yet specific mention thereof shall not be construed as a denial of the existence of others equally imperative, though not specifically mentioned. So, though they are not specifically codified anywhere, you are also supposed to follow the standards set up by the elders, that elders in the sense, elders in the profession, maybe our seniors, may not be our seniors, but elders in the professions, and we can as well call them stalwarts in the profession. We have to also follow the standards set up by them. So far as the Bar Council of India is concerned, they have mentioned certain rules which deals with duty to the court, because they are all, though not specifically mentioned as a part of standards of legal profession, we can as well treat them as one of those standards which are required to be followed. And duty to the court is first and foremost, and the relevant one is, an advocate shall maintain towards the courts a respectful attitude, bearing in mind that the dignity of the judicial office is essential for the survival of free community.
The next one is an advocate shall appear in court at all times only in the prescribed dress, and his appearance shall always be presentable. These are the duties to only few I am mentioning because they are relevant to the youngsters here. They have to maintain towards the courts a respectful attitude, which is very much important during course of, not only during the course of early days, even after putting up sufficient or adequate standing in the bar. They have to be respectful to the court, and their appearance in the court shall always be in a prescribed dress, and appearance shall always be presentable. So you have to, like when you are in robes, you should be wearing proper robes, proper bands, and this particular duty is also cast on the advocates when they are present before the court, whether they are arguing or not arguing. Whenever they are entering into the court, they should be in robes. Then duty to the client. An advocate is bound to accept any brief in the court or tribunals or before any authority which he proposes to practice at a fee consistent with his standing at the bar and nature of the case. So youngsters should make note of this particular provision or rule provided under the Bar Council, wherein it provides that the fee should commensurate with the brief they are accepting. They should not quote more fees. They should not. They need not quote less fees. They should be reasonable at least. Then comes, it shall be the duty of an advocate fearlessly to uphold the interest of his client by all fair and honorable means without regard to any unpleasant consequences to himself or any other. So he is duty bound to uphold the interest of his client in fair manner. Then an advocate shall not do anything whereby he abuses or takes advantage of confidence reposed in him by his client. You have to be impose or repose confidence in the client when you are accepting a brief by expressing rather your frank opinion, whether it is in favor of the client or it is against the client's interest. You have to tell that, see, this is your case, you may or may not win, but you have to tell the client so that you will repose confidence in the client. Then comes duty to the opponent. An advocate shall not in any way communicate or negotiate with the subject matter of controversy with any party represented by an advocate except through that advocate. So when you are dealing with the matter, you have to deal with the other side opposite advocate only with reference to the subject matter, that too in the interest of client. So these are all the few things or few rules which are framed by Bar Council of India to keep up the standards of the profession, legal profession. So when it comes to uncodified standards, because these are only guiding factors, even in the preamble it is mentioned it is only a guiding factor only. But so far as the other uncodified standards are concerned, we have to rather learn or follow the standards set up by the stalwarts in the profession. Say for example, Mr. Padmanabh Reddy, Mr. Justice O. Chinnappa Reddy, Justice Jaganmohan Reddy, or say for example, if you take from this area, Mr. G.V.K. Ramarao, father of Justice Swamiyajulu Garu, that is Mr. Surya Prakash Rao. They are all stalwarts. They have laid certain standards in the profession. The youngsters have to follow those standards, though they are not codified anywhere. By looking into them, by following them and following their standards set up by them, one would definitely flourish in the profession. See, I can say that వాళ్ళు ఒక రాచబాట వేశారు by following the professional ethics, standards. Even before I can say these rules are not framed the Bar Council of India. So when you are following the path laid by experienced and the professionals who have excelled in the legal profession by following the professional ethics, certainly it will be helpful to the youngsters, and it is also a due profession. See, మీరు చక్కటి రాజబాట వేసిన తర్వాత పక్కకి వెళ్తే కనుక అక్కడ ముళ్ళ కంపలు ఉంటాయి, బురద గుంటలు ఉంటాయి. సో ఇట్ ఈస్ ఫర్ యూ టు choose the right way, follow the right path in the profession. Then only you will be in a better position to secure a place in the profession, and tomorrow the followers, the youngsters who join the profession after you become a senior, they will follow your footsteps. You should be a role model. Like in the beginning, Justice Sashai Garu was saying that Mr. Jivika Ramarao is his role model. Likewise, one should also think, youngsters should also think that I should be a role model to the others. That they will achieve only by following certain standards, that is the professional ethics, the principles set up by our seniors in the profession. So, if you fail to follow the standards in the profession, follow the professional ethics, definitely you will not be able to achieve the pinnacles in the profession. So, you follow the standards set up, be it codified or not, that is a different aspect. But you have to follow the principles laid on, standards in the profession. And one more important aspect which I would like to emphasize is that you all know that the bar is the mother of the bench. So if the members of the bar follows the standards of legal profession, professional ethics, then they will be able to produce a good members to the bench. And if there is a failure on the part to follow the standards or the ethics, then there will be a shortfall of then the profession will not survive. That is my personal view, and I urge and also trust that the youngsters who are present here would follow the footsteps of the seniors who have laid the road or path, to follow them and follow the principles, the standards set up by them, so that they will also flourish. I wish all the best to the youngsters present here, and I convey my regards to the organizers, that is Bar Council of AP, for giving an opportunity to share my views on this particular topic. Thank you.
Thank you, sir. These rules are being supplied at the time of enrollment, but we read every book except that rule book. My lord, within a short period, presented very beautiful picture about our duties towards the court, towards the colleagues, towards the profession, towards the society at large. Now I request Justice Subbareddy Garu. As advocate, always he is with the tap, readily with the information, and after becoming the judge, number of times used to tell, in the court I will be able to discharge my function, but not. Today, we are able to convince him, and I hope and trust that it will be in the more and more occasions we will hear to him.
Sir, a good afternoon to all the members assembled here. Sir, it is already 1:45. If I start arguing a first appeal, now people will curse me. I don't do that. Even to decide first appeal, sir, it takes time. So I don't do that here at this point of time. Sir, today's president of the function, Sri Ganta Ramarao Garu, chief guest, Sri Aukuli Venkat Sashai Garu, guest of honor, Manavendra Roy Garu, Justice Jay Surya, my senior, and members of the Bar Council. The topic assigned to me is Civil Procedure Code. it's a vast subject. When there was a topic when there was a seminar in LO, Justice Sai took almost one and a half hour to discuss this entire, not entire, to the extent possible. If we start this now, sir, let's not do that. I'll confine myself to pleadings part. Because as an advocate now from the bench, I'm looking more often the cases I'm looking, because a number of cases I'm looking at thing that the pleadings are not precise or there lack of pleadings. That is the reason why I choose these pleadings for this today's subject. Pleadings are the foundation of the case. Everyone knew that. Of course, CPC Order 6 rules with pleadings. What is the object of the pleading? Any young friends, so that from there we'll start that. What is the object of the pleading? Seniors, they'll be teaching us all these things in our profession. But see, as youngsters, maybe freshers from the college, unless you follow what is the pleading, what is the material fact, what is the particulars, what is the object of pleading, will be not, when you are drafting a plaint or written statement, unless you know what is the pleading and material fact, will be missing the crucial point. By making, see, the basic, the object of the pleading is that to ascertain the issue in the, rather the list between the parties, be it plaint or written statement. Once you know the issue, it's the, for example, in a plaint, you ever a material fact, so that the other person in the written statement will deny and will come with his own case regarding that material fact. That is the purpose why pleadings, they always play vital role either in the plaint or written statement. And in fact, pleadings also narrow down the conflict between the parties or among the parties. When you are dealing with the pleadings, you have to state, even the pleadings also sometimes determines the burden of proof, as on whom the burden of proof lie. And also it helps the court while framing issues. Once the issues are framed based on the material facts, you will be knowing on whom the burden of proof lie under 101, 1 to 110 of the Evidence Act. One should not forget that you have to state pleadings in concise, but not, you need not plead the evidence while you are drafting the pleadings. And when it comes to pleadings, we can say that pleading should not, what is the material fact? Is it facta probanda or facta probantia? The question is youngsters to say what is the facta probanda and what is facta probantia. Of course, Ramarao Garu will tell us all these things because of his experience, or Mr. Prasad will tell this, but it's only youngsters, we should know what is the difference between facta probanda and facta probantia. Sir, these things are because maybe while I was in my office with my senior, probably I was spending with maybe up to 10 o'clock in the night, following senior by looking at all these things. Nowadays, with not that I'm commenting anybody, in the morning somebody is saying maybe after 1 year they are coming to, they are saying that we'll be grown up as advocates so that we want to practice on our own. Not that we are not finding fault with any advocate in that manner, but the only thing is you have to learn these from our seniors. Without that, maybe when it comes to, for example, recent past, maybe 1 week back, I come across a case where in a specific performance suit, the basic pleading with regard to readiness and willingness is not there. He asks for amendment. It comes to my court. What is that we do? If it is not there, the entire case will go. That is the reason why pleadings, they play a very vital role. And see, with regard to this facta probentia and facta probanda. Facta probanda means where the facts which need to be proved, that you have to necessarily state in the plea, either be it in the written plaint or written statement. Then facta probentia, that's the case where the facts, the material facts to be proved. Here is a case where the facts which need to be proved is facta probanda, and the facts through which material facts are proved is facta probentia. Every plaint should contain this material facta probanda. With regard to this, so difference is the number of judgments with regard to what is the difference between facta probentia and facta probanda. I need, for example, this 2007 Supreme Court 581, where the Supreme Court dealt with what is the difference between material facts and this material fact and material particular. No, sir. It's there with me. I'll give you, probably I'll give you this because it's there. I just only extract that some site, that case name only. So now with this, now I just want to say, when a case comes to us, you have to read the papers, then you have to draft it. In the morning, somebody is saying that now there is a procedural aspect. You have to draft 3 pages plaint, then all these things. So even 3 pages plaint also, unless you plead material facts in the plaint, and that fact should be either be denied or rebutted by the other side by way of written statement, and that leads to framing of issue. Court may not decide the list in a judicious manner. And so far issues are concerned, everybody knew basing on these pleadings, the court draft issues. The original practice of advocates filing draft issues, I think now it's been, we have given a go-by. And the original practice of drafting written statement where by denying the entire plain pleadings, then starting the written statement contents is also given a go-by now. Good olden days, because I have seen plaints or statements from this area and from Rajol, the world practice is that whenever a plaint is presented before the court, the written statement, they are denying everything from para 1 to para 10. Probably then para 11, they start their case in the written statement. That is the traditional practice of filing written statement by denying entire thing. For the reason, if you don't deny a particular fact in the plaint, that's called material fact, it's deemed admission. Senior advocates, they draft plaint in such a fashion, these material facts, one should not find, maybe will be confusing what is material fact, what is the material fact in this plaint. That's the reason why the world practice is that to deny everything from the plaint, then written statement they starts it. So my only suggestion to my young friends, to present either plaint or written statement with material facts, so that you will be in a better position either where you stand or when it comes from the defendant, you know where the defendant, what is the defendant plea and how to deal with that case. And it in fact helps the courts also. With this, sir, I only say, maybe if we continue, probably this will take another, but I don't want, because there are a number of issues we have to deal with, like, for example, when comes to civil procedure code, there are aspects of recalling a witness or filing of petitions to implead. All these things probably I'll reserve for the time being. Probably I'll take one more chance to deal with at a later point of time. It's already 2 o'clock now. And I only say because now maybe in the presence of Mr. Rama Rao, where because I came to Narsapur for the first time where Mr. Rama's specialization took place. A person, a stalwart of this district, because I am from Tadepalgudam, but I never come to this Narsapur. I only saw Mr. Venkatratnam Garu, a 50-year-old practitioner there, but after seeing this Ramarao Garu, where he is studying all these law journals, even today also, I just confined to this only for the time being. And I say that one should be meticulous in while drafting the pleadings. With this, I'll thank my organizers to give this opportunity. Thank you.
Thank you, sir. I request all of you to wait 5 minutes without rising from your seats. I promise that this will be over within 5 minutes. Justice Subbareddy Garu gave us cream of the drafting and pleadings. It is only introduction session. Within short period, there will be another session. I hope and my lord will not refuse. A detailed session can be held on only this CPC in a shorter period. With this, next program is felicitation of our guests. I request the other bar council members, Chandrasekhar Reddy Garu and Madhavi, to join us to felicitate today's speakers. One minute, Chief Guest Justice Seshai Garu want to tell few words.
మీ అందరూ చూశారు, విన్నారు. చాలా సిస్టమేటిక్గా జరిగిందండి అంతా కూడా. ఎంటైర్ క్రెడిట్ గోస్ టు బార్ కౌన్సిల్ అండ్ ది లోకల్ బార్ అసోసియేషన్స్. ఇన్ కంటిన్యూషన్ ఆఫ్ వాట్ మిస్టర్ సుబ్బారెడ్డి గారు said about pleadings, in recent past we are coming across the plaints and written statements in some cases filed in appeals. It is hard burning also. They are containing the citations also, sir, unfortunately. In contravention of what the provision says, or the 6 rules says, specifically says, it should be concise statement of facts only, not even evidence. Need not be. Cannot be pleaded. Correct. Let us avoid that, sir. And all of you know how extensively Sri Rai Garu enlightened us on Article 20 of the Constitution of India. As correctly said by him, it is one of the constitutional safeguard provided under Chapter 3 of the Constitution of India. And another speaker, that's what I said in the beginning, Surya, our district Surya. Chandra is Subbareddy Garu. He also enlightened us. చాలా విషయాలు చెప్పారు ఆయన. ఎలా ఉండాలి, ఏం చేయాలి, ఏం చేయకూడదు అనేది కూడానండి. ఆయన కొనసాగింపుగా ఒకటే నేను చెప్పేది, ఒక్క అలవాటుతో మనం ప్రారంభించుకుంటే చాలండి. ఒక్కరోజు సీనియర్ అయినా సరే మన ముందు నిలబడకుండా చూసుకోండి దయచేసి. నా విజ్ఞప్తి అదే. ఒక్కరోజు మనకు సీనియర్ అయినా సరే బార్లో మనం లేచి సీట్ ఆఫర్ చేద్దాం. అదే నాంది. థ్యాంక్ యూ వెరీ మచ్. థ్యాంక్ యూ వన్ అండ్ ఆల్.
The felicitation of chief guest of today functions is Justice Seshai Garu. felicitation of Justice Manavendra Rai Garu, Administrative Judge of this district, by the Executive Committee of the Narsapuram Bar Association. Now the felicitation of Justice Jayasuri Garu by the Executive Committee of the Palakollu Bar Association. Executive Committee members of the Palakollu Association. Now the felicitation of Justice Subbareddy Garu by the former President of the Narsapuram Bar Association and Palakollu Bar Association. Please come and
Now, felicitation to the Chairman, Bar Council of Andhra Pradesh. No, 1 minute. Now, presentation of memento to the Honorable District Judge by the President of Narsapuram and Palakollu Bar Associations. మీరిద్దరూ ఉండండి సార్. కూర్చోండి. Next, felicitation to the Chairman, Bar Council of Andhra Pradesh by the Presidents of Narsapuram and Palakollu Bar Associations. Now, felicitation to the Bar Council member Venati Chandrasekhar Reddy Garu by the presidents of Narsapuram and Palkol Bar Associations. Now, felicitation to Sri B.V. Krishna Reddy Garu, Member Bar Council of Andhra Pradesh. Now, I request all the lady advocates to come over to the dais to felicitate Madhavi, Bar Council member. I request all the lady advocates to come over to the dais. మీరు కొంచెం క్లియర్ చేయండి, లేడీ అడ్వకేట్స్ వస్తారు. తర్వాత మీరు కొద్దిగా దిగండి లేడీ అడ్వకేట్.
కొంచెం ఫాస్ట్గా పద్మలత గారు. Now I request the presidents of both the Bar Association to felicitate Mr. Chidambaram. Next vote of thanks by the Secretary of the Palkollu Bar Association.
On behalf of the Bar Association Narsapuram and Palkol, I offer my sincere thanks to the Honorable Sri Justice Sri A.V. Sesai Garu, Secretary Manvendra Nath Rai Garu, Nainala Jayasuriya Garu, Satya Subbareddy Garu, and Sri Chintalapalli Purushottam Kumar Garu, Sri Ganta Ramarao Garu, and members, Bar Council and Judicial officers for attending today's function.
Now, felicitations to Narsapuram Bar Association President and Palakollu Bar Association President by the Bar Council of Andhra Pradesh. Honorable Chairman Ganda Ramarao Garu, felicitate the both presidents దగ్గర నుంచి.
Now felicitation to the Secretary, Bar Council of Andhra Pradesh, Padmalata Garu, by the Narsapuram and Palkol Bar Associations. ఇది అయిన తర్వాత అందరికీ బయట లంచ్ ఏర్పాటు చేయడం జరిగింది. లంచ్ చేసిన తర్వాత అందరూ ఆల్ ది లేడీ అడ్వకేట్స్ ప్లీజ్ కమ్ ఓవర్ టు ద డయాస్. Thank you very much. Now, Janagana Mana. Continue. Start here.
जनगणमनाधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जाहे तव शुभाशिष माहे गाये तव जय गाथा जय गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you one and all. I request all of you to have your lunch.
వచ్చేస్తున్నారు చెప్పండి.